Good morning, sunshine. How are you? As we begin day 11 of the Karen Reed trial. Day 11. Wondering how many more days the state has left. I'd say at least a week. My gut. But I find whenever I'm trying to estimate how long a trial is going to go, they say they have a schedule. They don't share what that schedule is with us. Whenever I try to estimate, all of a sudden, I'm never right. That's like, I'm terrible at that. You have to know what your strengths and what your weaknesses are. My strengths and my weakness in assessing trials is knowing when the heck it's going to end. Every time they're like, they're planning for arrest, prosecution arrest. I'm like, wait, really? Every time. So, I don't know. Did I miss anything? I didn't miss anything. Of course I didn't miss anything. Don't be silly. Don't be silly. Minutes. I'm looking to make sure the fan was spinning the whole time. Yeah, I didn't miss anything. But it is just about time for us to get our butts into the prestigious courtroom. I'm told the jury wants to see me. As the jury coming in, why don't you come up to Sidebar? That's what she opens with this morning. Come on up to Sidebar. We get anywhere since then? That was a minute and a half ago. There's no way that she got through the jury's questions yet. This is like my court look. That she has to jury her famous 3 questions. Have you been digging and ferreting, conducting your own investigation? Have you reached termination and disseminated across the internet? Were you the one who killed John O'Keefe? Those same 3 questions every morning. And that's actually the least of the flaws that she has. That's technically proper procedure that she is following there to ensure that the jury is retaining their neutrality. Do I believe that they're genuinely retaining their neutrality? No. Do I believe that they're genuinely not looking anything up? Like all 12 of them? None of them did? No. But I think if you ask them every day, and they know they're going to be asked every day, fewer of them, perhaps. But it doesn't hurt. Motivate them to feel like that's something they should be taking seriously. If you don't ask about it, then none of them will take it seriously. So I do think it's a healthy thing to ask them, even though I assume that in most juries, a couple of them, the overwhelming majority of juries, at least a couple of them, if not all of them, are lying to you. I'm just being real. I'm being real. You do have a couple who will follow it also because they feel like they're answerable. A few of the more accountable ones. You also have a few who are just so sick of hearing about this trial that they just won't check. I don't have enough care. I don't care enough about this trial. I don't even know if his father was even alive. We always hear Margaret O'Keefe. I know nothing about his dad. I feel ignorant about the dad. I seriously question whether he was alive. Oh, wait, they got divorced. That's right. That's what Margaret O'Keefe said. I think she said they got divorced. That's my recollect. That's my recollect. Pinochet's helicopter says, regarding Bondi last night, you aren't stupid, you are naive. Oh, okay. Bondi prostrated herself for Pfizer. If it colors everything going forward, she will prostrate herself for the corporate elites. This could be similar to what I was just talking about right now. It depends on the nature of the character of a person. And she could be your classic neocon. I had a neocon vibe about her and asked someone who I trust, is she really going to stand up for these principles? And this was someone, I'm not going to throw this individual under the bus, someone that I like and respect. That's why I asked him. I was like, yeah, this one's a good one. So I was like, all right. There were some people who had raised some doubts about her beforehand. And the jury is not out on Pam Bondi yet. Pardon the pun, given the situation. Now, you tell me that since she works for Pfizer, she's working for Pfizer when she's in a private capacity. A lot of people would take, would find it easy to accept the money when they're in that situation, and then they enter a different role. And the question is whether they take duties of that seriously or not. And we're right to be cynical. You're right to be cynical, Pinochet. The same way I was expressing cynicism about whether the jury follows the instructions that the judge has, or whether we can count on human nature poisoning their otherwise good virtue. And you too, similarly, we can speculate about Pam Bondi, that human nature seems to win out far more often than it loses. And the negative aspects of human nature tend to win out, particularly when it comes to vanity, fame, wealth. They do. They tend to win out. But we can always hope. And since there is hope, why prejudge? You can be cynical and skeptical. Let's see what we get. Bid saying, I doubt her ability. You want me to check the DM that you sent me on this? Check my DMs. Oh no, you just sent it. All right, I'll pull this up since this just was posted 6 minutes ago. It was shared with me by Sandy. So we'll pull this up real quick because I was talking about Pam Bondi last night. If you missed my show.
Of Epstein with. No, the FBI. Yeah, the FBI, they're reviewing. There are tens of thousands of videos of Epstein with children or child porn. And there are hundreds of victims. And no one victim will ever get released. It's just the volume. And that's what they're going through right now. The FBI is diligently going through that. I haven't seen that statement, but I'll call him later and find out.
See how the facial expression at the end there, especially, is like, just looks like she's not sure what's happening.
But I'll call him later and find out.
Right there. See that face? That face. Where you're just like, she makes that face a lot. It doesn't have a look of confidence. It has a look of what's happening here, which is why people like Beds question her competence. Is this loud enough? Is that? I assume it's loud enough. Oh, you're very welcome, Max Deplorable. Thank you for your support. Appreciate that. She just doesn't come across as someone. She looks beatable when she gives that face of. She looks very beatable. I mean beatable as in, like, you can see there's a certain insecurity type of thing where you can see her becoming submissive to an alpha in a room. Like she would just, in a courtroom, you can picture her sort of cowering. Cowering to like another attorney like Alan Jackson. Like that. If she was litigating against Alan Jackson, I would feel very little confidence that she's going to beat him. It's a fair point. Now, I haven't seen her practice law, and she's not the one who is practicing. Like she wouldn't be the one litigating in the room. But she doesn't exude confidence. That's true. And that's concern. I mean, by the binders thing, she was in Mitt Romney's binders full of women. I'm kidding. No, she was the one who gave out the binders to the influencers. Yeah, which was a fiasco. Why do I have this up here? This was, yeah. That's a good way of praising it. Like I said, it's like kind of like a beta type of thing. Where you just like, this doesn't feel like a leader. When she does try to express leadership, it feels forced. We are gonna come after you. Like, I don't feel it. I mean, it could be the expression she's giving on the tone of her voice. I always try analyzing, like, what about her? What about a person makes me feel intuitively a certain way? That's what I've always done since I'm a kid. That's where I started becoming like hyper analytical of people. I'm trying. It's not a matter of judging. It's like I just sort of want to understand, like why I intuitively feel a certain way, or others feel a certain way. Like what about their perception is giving them that takeaway, or giving me that takeaway in this case, and others obviously.
Judge, while we're waiting for the jurors, just for the record, I think Ms. Little had an opportunity to review the redacted exhibits from yesterday, and I don't think there was any objection to them.
That's correct. All right, thank you.
Jurors taking their time. Show the fans we don't accidentally see a juror. That's probably the instruction of the judge, that every time the jury comes in, we to ensure that we're not going to accidentally see one of them, focus on the fan. And that's logical. You don't want some, my God, that buzzing of the fan. I don't know if this is the buzzing of the fan, but my God, that's annoying.
Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable Beverly Canoni, the Justice of the Superior Court, holding in Dedham, within and for the County of Norfolk. Draw near, give your presence, and you shall be heard. God save the Commonwealth of Massachusetts. This court is in session. Please be seated.
All right, good morning again, counsel. Good morning, jurors. I have to ask you those same three questions. Were you all able to follow the instructions and refrain from discussing this case with anyone since we left yesterday? Everyone said yes or nodded affirmatively. You also able to follow?
That's what a lot of people say.
And refrain from doing any independent research or investigation into this case? Everyone said yes or nodded affirmatively.
And it could be.
Did anyone happen to see, hear, or read anything about this case this week?
It could be that's just her natural element. is the courtroom, and she's much better in there. That's very possible.
The Commonwealth calls Connor Keith.
All right, let's get back into the Karen Reed trial. What did he say? Connor Keith? Is that what he said? Connor Keith? I gotta put my ban up. My banner. Maybe it's Colin O'Keefe. Maybe it's O'Keefe. It's probably O'Keefe. That's probably what happened. It's probably a relative, O'Keefe. Not Keith. I thought the closed caption got me with the Keith. It's probably a relative, right? That's what I'm guessing.
Step up, raise your right hand. Thank you, clerk. Thank you.
Raise your right hand. You solemnly swear the evidence you give to the court and jury in the case now hearing should be truth, the whole truth, and nothing but the truth, so help you God.
Yes.
All right, Mr. Brennan, whenever you're ready.
Thank you, Your Honor. Good morning.
Good morning, sir.
Could you please introduce yourself to the jury, spell your last name for the record?
Sure. My name is Connor Keefe. The last name is Keefe.
Oh,
Mr. Keefe, where do you work?
I work for the Massachusetts State Police.
What's your position with the Massachusetts State Police?
I'm assigned to the Norfolk District Attorney's Office.
Are you a trooper?
Yes,
When did you first start beginning working as a Massachusetts State Police trooper?
2017.
Did you go to basic training?
Yes, the academy.
How long was the
not
academy?
a relative.
Approximately 6 months.
Did you have any further training after the academy?
On the job training?
Yes.
Yes. In various specialties.
What's your role at the Norfolk County District Attorney's Office?
I am assigned to the homicide unit where we investigate homicides, unattended deaths, suicides, stuff like that. And I'm also a digital forensic examiner at the District Attorney's Office.
Did you have a role in investigating this case?
Yes.
Were you assigned investigator in this case?
I wasn't the main investigator, but I was involved, yes.
Did you deal with any of the digital forensic evidence?
Who was the
Yes.
main investigator?
Specifically regarding the digital forensic evidence, did you meet anybody to obtain a phone?
Yes.
Who did you meet?
I met Jen McCabe and Kerry Roberts.
When you met with them, did you have to obtain anything from them?
I obtained a consent form and their cellular device.
After you received their devices, where did you bring them?
They were brought back to the forensics lab located at the Norfolk District Attorney's Office.
And what, if anything, did you do with either or both phones?
I conducted a forensic extraction on those devices.
An extraction, is that a copying an image of the phone?
Yes.
Is that different than analyzing the phone?
Yes.
Were you involved in analyzing Kerry Roberts' phone?
No.
Were you involved in analyzing Jennifer McCabe's phone?
No.
Was your role limited to attaching it to grade key and doing the extraction?
That is correct.
And did you do that?
Yes.
In addition to the phone extractions, if you take us back to January 29, 2022, were you involved in going to 34 Fairview Road in Canton, Massachusetts?
Yes.
Do you know about what time you went there?
Approximately 5:30.
What was your role at 34 Fairview Road that evening?
I was asked by my supervisor, Lieutenant Brian Tully, to assist in processing the scene at 34 Fairview Road in Canton, Massachusetts.
When you arrived at 34 Fairview Road, was there anybody else there?
Yes.
Who was there?
Lieutenant Tully, members of the Massachusetts State Police CERT team, the Special Emergency Response Team.
Are you part of the CERT team?
I am not.
Did you see what the CERT team was doing?
They were conducting an area search very front of the lawn and the street or road in front of 34 Fairview.
Did you have any role in that actual searching of evidence?
No, I did not.
What was your role, limited role that night?
To process any evidence that was discovered during the search.
When you say process the evidence, can you explain briefly, what does that mean?
Sure, I was had evidence bags, and if a piece of evidence or an item was found, I would place that item into the evidence bag.
And why would you do that?
To secure it.
How How would you become aware if there was a piece of evidence found?
The CERT team would alert the supervisor, Lieutenant Tully, or myself that there was an item or a piece of evidence, and Lieutenant Tully would then take a photograph of it, and then I would secure the piece of evidence in a bag, evidence bag.
Do you know if those photographs were time-stamped?
I believe so.
Your role was to put the evidence in the bag and return it to the evidence room?
Correct.
Did you do that?
Yes.
If I could begin, I'd like to show you on the screen a series of exhibits. If we could start with Exhibit 74, please. Trooper, do you recognize that item?
Yes.
What is it?
That is a black Nike shoe.
Did you see that item that night?
Yes.
74A, please. 74B. Thank you. Is that the same sneaker?
Yes, sir.
After you were alerted to that sneaker, did you place that sneaker into an evidence bag?
Yes.
Did you bring that item with you today?
Yes.
Very
Do
exciting.
you have gloves?
Yes, sir.
Let's see the shoe. Show us the shoe. We need to see the shoe.
Do you want the lights on, Mr. Brennan?
Yeah,
Please, thank you,
we'll
Your Honor.
see
And
the
Ms.
shoe a
Gilman
lot
can take
better.
the photo down,
Lights
please.
are on.
With the court's permission, I'm going to move this piece of evidence, item into evidence. Let me ask you a few questions before you open it. Could you stand and show that bag? There's red tape on it. What's that for?
To secure the bag closed.
If the bag is open, is it then retaped?
Yes.
Do you write on the outside of the bag?
Yes.
Why do you do that?
To memorialize the date, time when the evidence was collected.
Could you open the bag and show us what's in it?
Yes, sir.
You're going to reseal it back in that bag and then memorialize day and time again? Because that could happen 1,000 times. The unveiling of the shoe. It's a sign. It's a sign. He's telling us that we should walk forward in life. Hold up the holy shoe.
Sorry.
No. He's saying, don't walk over others. That's not what the sign says. The sign says, just do it. That's why it's a Nike shoe. Sorry, Governor, it's not a shoe. It's a trainer. What? We're American. There's no such thing as trainers here unless they're working in a gym.
With the court's permission, can he show the item?
Yes.
Should be emitting light. Oh, there you go. Definitely a shoe.
Trooper, is that the same item that you found that night?
Yes, sir.
If you can place it back in the bag.
We didn't get that from Foot
I'd
Locker,
ask
right?
this to be marked as an exhibit.
All right, any objections, Mr. Unity?
There is no question.
Is there a reason it doesn't have snow in it anymore? By our estimation, the snow likely melted by now.
Sir, you mentioned there's writing on the outside of the bag.
Yes.
What type of information do you write on the bag?
Date, time, location, who was collecting it.
The time that you write in the bag, is that the specific time the item was found, or does that represent a different time?
That could represent a different time.
And why would that be?
If you're processing multiple things at once, you're bagging things at different times, then when you seal the bag, that could be the time that is annotated on the bag.
Can the item be found before the time on that bag?
Yes.
Would you ever write a time later than when the item was found?
Yes.
I'd like to move now to Exhibit 75, please.
Hank Brennan here is trying to alleviate all the concerns that Alan Jackson is raising as far as chain of custody and the time written on something. And he's going to try and explain. He's trying to set up for, we know there's going to be issues with the timing of the Lexus and what time that is admitted into evidence. So and say that wasn't because the police were acting nefariously. That's just the way it happens. It could happen that way with a shoe, or with a car that later is revealed to have a broken taillight. That's what he's setting up here. He's also trying to bolster that this guy was here. He's not part of the search. Yesterday, Alan Jackson was asking all these questions about the legitimacy of that search and whether there are other people around. Well, this is one of the other people around. He doesn't seem like someone he doesn't give off an aura of someone who's planting evidence. So he wants to alleviate those concerns for the jury. And that makes this witness in many ways pretty important as far as rebutting a lot of what the defense is trying to claim. At least for jurors, if not for you individually. Just makes the other evidence have a feel legitimacy and strengthen the chain of custody issues. Some baby-faced, fresh out of trooper school guy come out there looking so innocent.
Do you recognize that item?
Yes.
It's a red Solo
One
cup.
of the items you bagged that night?
Oh, no.
Yes.
And if we could turn to 76A, please. Do you recognize that item?
Yes.
Is that an item that you bagged that night?
Yes.
Do you have both of those items with you?
Yes, sir.
Could you produce those, please? Ms. Gilman, you could take that down, please. Thank you. 570.
Beverly looks happy today. She's like, oh, we're putting in the evidence. This'll
Yes,
nail
sir.
her.
With the court's permission, I'd ask the trooper to open the bag and show the jury.
This does seem like a whole spectacle they're doing about the opening of the bag. When they literally could have taped that bag up and written that note this morning. They could have practiced this 50 times. That could be the 87th bag that they've ever had that says the same words on it. But formality is a nice thing. Don't cut your glove on it. There's enough DNA on it already. Let's see the tail light. The shoe did look brand new. Okay. So there we go. Definitely looks like it came from a tail light.
Sir, on those items that are stickers, did you put the stickers on them?
I did not.
Do you know where the stickers come from?
Someone did.
I do not.
Do you know if these items are ever sent to anybody other than your evidence locker? Are they ever removed and given to lab personnel and technicians?
Yes.
Do you know if that was done in this case?
Yes, I do.
Inside that bag, is there just two pieces or is there another piece in that bag?
There was another piece in the bag.
When you put the taillight pieces in that bag, how many pieces did you put in the bag?
I put 2.
Do you know if the other piece in the bag is a piece that broke off, or do you know how that arrived there?
I do not.
Could you just pull out that other small piece and show the jury as well? Is that smaller piece consistent with the same color as the two bigger pieces?
Yes.
Is it consistent with the same material?
Yes.
If you could put that back in the bag, please. I'd move this into evidence, please.
Okay.
Sidebar. Seems not too happy about the admission of that little small fragment there. Well, so now we have admitted a shoe. Likely the tail light is going to be admitted. I'll tell you right now. Chances are that it's going to be admitted. A lot of people were very excited to see what Victoria Little, former alternate from the first trial, who has joined up with the defense team, is what contributions she's making, which few, if any, have been visible to us until today. where they mentioned that she was reviewing certain evidence, I believe it was text messages or something, and saying that it was admissible without redaction. So she's working. She's doing something. Maybe she goes up there and she holds Karen Reed's hand. I'm not trying to undermine her significance in this case, other than to say it's not visible to us, but that is Miss Little right there.
So, Mr. Brennan, I leave it to you and the witness how you do that part.
Yes. Sir, on the small chip piece, you don't know how it became chipped?
I do not.
I'd ask you to remove that chip.
Oh, no one knows that it was found at the scene.
I'd like you to safely secure it, bring with you, and bag it when you leave.
Yes,
We're
sir.
taking that out of the
I'd like
evidence
to introduce that exhibit.
without the chip piece. We
We're
saw
going to mark the little chip.
we saw
You want me to
pictures.
mark
Giannetti
it?
asked to mark that. Yes.
And we're going to submit that for identification.
We
So
saw
the
pictures
small
of them
chip-
finding the
Madam
other
Clerk.
big pieces, but not that
Madam
little
Court
piece.
Reporter has an envelope for that.
Thank you very much.
Exhibit 78.
Thank you.
And this witness doesn't seem to know where that chip piece came from. He's just saying it looks similar.
BB for identification.
Thank you. Trooper, we have one more bag of items to go through.
Yes.
Could I have exhibit 73, please? Sir, if you could look at exhibit 73 on the screen, do you recognize that?
Yes.
And what is it?
A piece of clear plastic.
Is that piece of clear plastic, when you saw it, was it at ground level?
Yes,
Did you bag that item?
I did.
When you bagged that item, was there another item along with it in the same bag?
Yes.
May I approach, Your Honor?
Yes.
The two bigger shards had a baby shard. The reason it's significant is because it's important. They're saying, how can he introduce this evidence? Whoever found that little baby shard,
I'm showing you a photo.
baby sharp, whoever found it,
Yes.
What's in it?
The
the
piece
ones
of
that
clear
did it.
plastic.
Is that the second piece in the bag, separate from the last exhibit?
Yes.
Is there an accurate depiction of how you saw it that morning?
Yes, sir.
I'd move this into evidence as an exhibit, please.
I think
There's
that's
no objection, Mr. Giannetti?
There's no objection, no.
I think that's because they want Proctor to come in there and testify to get this other
With
evidence.
the court's permission, could we show exhibit 79 to the jury?
Yes.
Ms. Gilman, would you be able to close? Thank you. You recognize that item, sir?
Yes.
And did you bring those two items with you, the past exhibit and this exhibit?
Yes.
Could you produce those, please?
Okay, that's actually a phenomenal point. The shoe in the photo does have a black bottom, not all white. Yeah, that is weird.
Are these different in color than the last pieces you showed?
Yes.
That's a great
With the
point.
court's permission, could the trooper show these pieces?
Yes.
Another great point. How the hell did that get in there? But it could be that it wasn't tainted. This little that has two pieces. It looked like one piece in the picture. Why is it two pieces now?
Thank you, trooper. I'd move these items into evidence.
No objection, Your Honor.
Right.
Just because
Thank you.
they were found separately doesn't mean that, or they seemingly were found separately.
Thank you.
Or they may have been found separately. That doesn't mean all the
Any
evidence. is
questions,
tainted.
Mr. Giannetti?
Please, Your Honor, thank you.
Good morning, sir.
Good morning, sir.
Trooper Keefe, you testified that you received the cell phone of Jennifer McCabe and of Terry Roberts.
Correct.
With regard to the cell phone of Jennifer McCabe in particular, you had her sign what is called a consent form, correct?
That's correct.
What is a consent form?
It allows the trooper or law enforcement to, with the owner's consent, we are able to conduct an extraction of the device.
Okay. And on that consent form, there is a description of the item itself.
Yes.
In this case, it would have been an iPhone 11.
Yes.
And there also is an identifier with regard to a specific phone called the IMEI number.
The International Mobile Equipment Identifier.
Okay. And that would be included on the form as well because it identifies the specific iPhone 11 that Jennifer McCabe had, correct?
Correct.
The password was provided on that consent form,
Yes.
and the form was signed, correct?
Yes.
By both Jennifer McCabe and by you, correct?
Yes.
And there was also a second trooper that would have signed the form as well.
That's correct.
With regard to the timing of the signing of that form, Jennifer McCabe dated it February 2nd of 2022.
Yes.
You also dated it February 2nd of 2022, correct?
Correct.
Jennifer McCabe did not list a time, but you did, correct?
I would have to look at the consent form.
Okay, so your memory, you don't remember what time you indicated or if you indicated a time, but looking at the consent form would refresh your memory?
Yes.
May I approach, Your Honor?
Yes.
Now, I just ask you to read that silently and then look up at me when you're done, Trooper. Having reviewed that form, does that refresh your memory as to whether you indicated a date and time?
I did, yes.
And what was the date and time that you indicated?
It was February 2nd, 2022, 12:08.
And that would have been 12:08 p.m.?
Correct. 12:08 p.m.
The document that I handed you is not an original, correct?
No, it's not.
Does it appear to be a precise copy of the original, however?
Yes.
May I offer that into evidence, Your Honor, please?
Is there an objection, Mr. Brennan?
No, subject to redaction.
Okay. So don't put it up on the,
I will not.
Exhibit 81.
Now, Trooper Keefe, as of January 29th of 2022, you were colleagues in the same state police unit as Michael Proctor, correct?
I was.
At that time, was the unit called the CPAC unit or was it called Norfolk County Detectives?
I don't recall when it changed.
Okay, it's been called both, correct?
It has.
As of January 29th of 2022, there were only 10 troopers in the unit, including supervisors, correct?
I don't know.
It's a small unit, is it not?
Relatively small.
Within the CPAC or the Norfolk County Detectives, every case that comes in is assigned to one particular trooper as the lead investigator in the case, correct?
That is something that a supervisor would do, not me.
And have you been assigned as the lead investigator in other investigations?
No, not a homicide investigation. No,
You have not yet.
no.
Is it good?
The lead investigator is the trooper who is responsible for the case, correct?
Yes,
Michael Proctor was the lead investigator for the investigation into the death of John O'Keefe, was he not?
yes.
If somebody asked within your unit while this case was going on, whose case is it or who has that case, your answer would have been Michael Proctor, correct?
Yes,
The two of you have worked cases together in the past, correct?
a few.
You've worked on this case with Michael Proctor, correct?
Yes.
And in fact, within your work on this case, you actually partnered with him for certain assignments within the case, did you not?
You'll have to be more specific.
Sure. So for instance, on October 21 of 2022,
I like Yannetti.
you and Michael Proctor interviewed Sarah Levinson together, correct?
No, I don't recall that.
He's setting up here. He wants the jury to be thinking about Michael Proctor. At this point,
If I may just have a moment, Your Honor.
now Michael Proctor's hands are all over this case, and he's using this guy who is an underling to Proctor to help entrench in the jury's recognition that Michael Proctor is the guy. And later we're going to tear down Michael Proctor because they told us in the opening statements they're going to be tearing him down and that he was an utter disaster. But they want to have this guy use this witness of the states to entrench. We're not just the ones telling you that Michael Proctor, we the defense are not the ones telling you Michael Proctor was the guy on this case. We want them to tell you that Michael Proctor was the guy. This is Michael. This is, I think it's Michael's first name, but this is Yannetti who's crossing him.
Do you not remember interviewing Sarah
He's good at this.
Levinson on October 21 of 2022 at 12:20 p.m. at the Norfolk DA's office? Is that your current testimony?
Yes.
Okay. If you saw a copy of that report, would that refresh your memory?
To an extent.
May I approach you on it?
Yes.
That may be a better way. That may be a better way of putting it. Just show it now. Just show it now. Appreciate it. Your hot mic is too loud. Yeah, someone tell them to turn their mics off when they're having a little whisper moments. Because we're stealing your signs. Let's see if we can make up some ground here. A few seconds.
I've placed a document in front of you. I would just ask you to read that silently to yourself. Look up at me when you're done.
Yes. Brand it. Brand Proctor's name everywhere. Okay. Reading. A lot of reading.
I'm not going to ask you any questions about the specifics of what Sarah Levinson said. So
Memorize it.
you
I'd just
don't
like
have to
to-
brush up on that.
I'd just like to refresh. Take a
Sure,
look, sir.
go ahead.
He was like, I just want you to see your name on that report. That's all. You don't have to memorize it. He's like, no, I got more to read there. It's a whole freaking book.
Having reviewed that report, does that refresh your memory as to whether or not you participated in an interview of Sarah Levinson with Michael Proctor on October 21st of 2022?
Yes, I don't recall the specifics, but
So when you say yes, is it your current testimony that your memory is refreshed that you were actually there?
yes.
Okay.
See, he's clarifying. It's a good thing Yannetti does. Let's make sure I
The
understood
two
your
of
answer.
you would have participated in that interview together, correct?
Yes.
But you did not write the report, correct?
No, I did not.
Michael Proctor wrote the report, correct?
Yes, he did.
He was the lead investigator writing the report, correct?
Yes, he wrote this report.
He chose the language to use in that report, correct?
Keith is
I
embarrassed.
did not
by
have any
Proctor.
input on how he wrote this report.
Right. You had no input. You weren't standing over him while he was typing it, correct?
Correct.
You can see his humiliation about Proctor on his
Now,
face.
other examples
This
of,
kid.
and actually, let me take that back from you if you don't mind.
He's like, I didn't write this report. No, I didn't. No.
You are.
Kind of embarrassed I ever met Michael Proctor.
Other examples are the reports on the videos that well, strike that. Let me start by saying this. You, or asking you this, you retrieved videos from both the Waterfall Bar and Grill and CF McCarthy's, did you not?
That's correct.
You and Sergeant Buchanan retrieved the videos from CF McCarthy's, correct?
Yes.
But lead detective or lead investigator Michael Proctor was the one to analyze the video and write a report on it, correct?
I would have to see that report, sir.
Sure.
Well, here we go. You can buy yourself some time, kid, but you're going to see the report. That's definitely going to come into your purview right now. You know you don't like hearing his name, but you're going to be hearing it a lot
Okay.
during this cross.
Oh, I'm sorry. And again, if you read that silently to yourself and look up at me when you're done.
Mhm. We are live. I need 2,000 more likes, but yes. Thank you. Thank you, Sandy.
Okay, having reviewed that report, does that refresh your memory about Michael Proctor being the one to write the report on the analysis of the waterfall video?
Sir, I only obtained a copy of the surveillance video. I
Right.
did not do any analysis
Leave
on
me
the
out of
video.
it.
That's
Get me
my
out of
question. It was Michael Proctor who did the analysis, correct?
Yes.
And that, by the way, I said waterfall. Is that CF McCarthy's there, or is that waterfall?
This is CF McCarthy's.
Okay, I meant CF McCarthy's. He was the one to review that video, correct?
Yes. Again, I only got a copy of the surveillance video.
That's
Sure,
right.
I did
We're
not
not
do
trying
any
to
analysis.
And with
you.
regard to the Waterfall Bar and Grill, that was another circumstance where you and Sergeant Buchanan were the ones to retrieve the video, correct?
Yes.
But again, lead investigator Michael Proctor was the one to analyze the video and write the report on it, correct?
Yes, I would have to see that report as well, sir.
See, the kid doesn't
Now-
know the score here. The kid thinks that he's the one whose neck is in the noose here. He doesn't realize he's being used as a prop to hang this entire case on Michael Proctor. He thinks he's going to be blamed for whatever went wrong here. He's like, I didn't. That's why he's trying to evade any sort of guilt, blame for screw ups that happen here. And he's, feeling uncomfortable on that. He doesn't realize that the score here is we just want the jury to just associate everything related to any evidence they see here with the complete and total screw up that is Michael Proctor. Whereas Jack correctly pointed out, this is a proctorology exam that's going on now.
Another member of
And he just happens to be the
unit
participant.
was Trooper David DeChico, correct?
Yes.
Within your unit, did Trooper DeChico have a nickname for a first name?
Objection.
May we approach?
I don't know what Trooper DeChico. I don't know what the deal is with Trooper DeChico's nickname, or why there's an objection, or this is like such a big deal that we need to approach over it. But I guess he's going to be referenced by something else later on, and the jury and Yannetti wants the jury to recognize that when you hear that name, much as like when we hear Coco, we think of Nicole, Jen's sister. So too, Nicole Albert. So too, when we hear DeChico's nickname, that we will associate it and recognize it. So that's probably what this is about right here and now. I think I'm still current. Right? Oh, I'm not.
Troopers that were in your unit as of January 29th of 2022, which members of the unit had the least amount of time in the unit at that point?
Me? I was the baby.
I don't recall.
Were you one of the newer members of the unit?
As of January of 2022?
Yes.
Yeah.
Yes.
Trooper Michael Proctor had more experience than you did as of January 29th of 2022, correct?
He could have. He'd been on the job longer.
So then,
Okay.
yeah.
Well, if he had been on the job longer, then certainly that means that he did have more experience,
You're
correct?
not going to successfully evade here,
It
kid.
depends.
You attended the autopsy of John O'Keefe on January 31st of
I did.
2022. And with regard to other members of your unit, you were the only one to attend that autopsy?
Yes.
That was done at the medical examiner's office
The medical examiner's office in Sandwich, Massachusetts.
in Sandwich, Mass. And it was Dr. Irene Scorti-Bello who performed the autopsy, correct?
Yes.
Had you met her prior to that day?
No.
Had you spoken to her prior to that day?
No.
Did you know before the autopsy was performed that your former colleague, lead investigator Michael Proctor, had discussed the case with Dr. Scorti-Bello without telling us what you knew of what was said?
Objection.
Assumes facts, not evidence.
With regard to Dr. Scorti-Bello's knowledge of what the state police theory was of what happened, did you have to explain that, or was it your understanding she already knew what your theory was?
Objection.
Mrs. Staines, you can ask that differently.
What, if any, conversations did you have with Dr. Scorti-Bello about what your unit's theory was about what happened to John O'Keefe?
There was no theory.
Okay. You did not provide any theory to her, correct?
I did not provide a theory.
You learned at the autopsy from your observations that John O'Keefe had 2 black eyes and a swollen right eye, correct?
Yes.
You also learned that there was a small cut above his right eye, correct?
Yes.
And there was a small abrasion on the left side of his nose, correct?
I would have to reference the report for the exact words.
Okay. If I may have a moment.
That's a morality question. This is a morality, and you can take that's a fair take.
May I approach, Your Honor?
Not everyone would have the same take, though. To say he owns as much as Proctor, when he's a junior guy to Proctor, may not have been aware of different things, flaws that Proctor did wrong. You can hold
I placed
that.
another
You can hold that
document
line.
in front of you. Just take a
Not
look,
everyone
read it
will.
silently to yourself, and look up at me when you're done.
I know too little about what Proctor did and what he did to make any kind of call on that right now. But it's a fair point to be raised.
And I would direct your attention to the second page for the question I just asked you.
Yes.
Oops.
Yes.
Now, was this the first autopsy that you had attended, or had you attended ones in the past?
I cannot recall.
It could have been the first one.
Most likely not.
When
One of
you're
the first
attending
few.
an autopsy as a member of the CPAC unit or the Norfolk Detectives Unit, you are expecting that the medical examiner is going to examine the body, correct?
Yes.
And you're there to witness that examination, correct?
Yes.
At the end of the examination, you are expecting that there will be a determination as to cause and manner of death, correct?
Not.
In this case, when the autopsy ended, you left the medical examiner's office, correct?
Yes.
When you left, your understanding was that the cause and manner of death was still undetermined, correct?
Objection.
You knew when you left that Dr. Scorti-Bello had seen the scratches or bites or injuries to John O'Keefe's arms, correct?
Objection.
You knew when you left that in your presence, Dr. Scorti-Bello had seen the injuries to John O'Keefe's arm.
Object to the line of questioning.
Sustained.
May we approach?
Yeah, I'm not sure about these objections either.
Jurors, feel free to stand up.
I'm actually a little bit torn here as to like what the nature of the objection is. I guess, did he really know what the other person saw? Perhaps if he words it differently, did you see them or looking at the abrasions? You know, it's sort of, it could be a foundational question. Well, he established he's attending the autopsy together with the ME. It's a foundational question. You would think that that could be remedied by saying, did you watch her examine every portion of the body? He looked at his face, he looked at his nose, he looked at this, looked at that. That's his foundational question. If it's a matter of, as far as the framing of it, that you're saying that he's asking about what he knew was seen versus what he observed her looking at. So that could be the basis of the objection being sustained. If I see you looking at a picture of someone whose face has a bunch of tattoos, and I say you knew that person had, and later on I testify about you looking at us, and I say you knew that person had a mark on their lip. It's like, well, maybe you didn't even look at, you weren't focusing on that. There's no way you could know what that person saw. So that could be the nature of what's going on here. Make sure we're live. We are live. To follow up on what Pinochet said, we were talking earlier about Pam Bondi and so her questions of her ties to Pfizer, whether that makes her corrupt. How did Gideon pick his soldiers, not the ones who were naive and lapped at the river like dogs, but the ones who kept their hands on spears and their eyes on the horizon towards the enemy? That's true. I actually say...
Were you watching Dr. Scorti-Bello as she was conducting the autopsy?
Yes.
Did she appear to be looking at John O'Keefe's body?
It's the same thing, just asking different.
What direction were her eyes facing?
I got it right.
When she was examining John O'Keefe's body?
Towards the body.
I don't recall.
Okay. Was she looking at the ceiling, Trooper?
She was doing her job conducting the autopsy.
And in order to do that,
body,
I'm sorry?
she was looking at the body. I
Well,
assume.
Good.
Not in,
That's all we needed.
And looking at the body, you saw her looking at the body, correct?
yes.
And looking at the body included an arm, correct?
Yes.
And it was at the arm was not covered up during the autopsy, correct?
No.
It was open for you to see, correct?
Yes.
For her
And
to
you
see.
saw the injuries to John O'Keefe's arm, correct?
Yes.
You didn't see any bruising on his arm, correct?
I don't recall.
You didn't notice any obvious broken bones, did you?
I'm not a medical expert.
This is where his ignorance helps.
And it is common practice for the state police to attend autopsies
Or
when
play
there's
ignorance.
an
helps.
undetermined death, correct?
Yes.
It is not at all common for the defense to attend an autopsy, correct?
I've never experienced that.
Right. And there was no defense attorney or defense expert at the autopsy of John O'Keefe, correct?
Not when I was there.
You were there, correct?
Yes.
And there was nothing that prevented you from giving input to the doctor as she examined the body, correct?
We don't give input. We give the facts that we know so far in the case.
Okay. Well, giving the facts is giving input, is it not?
It's not input.
Okay. Did you talk to Dr. Scortibello during the autopsy?
Yes.
And you gave her information, if you don't want to call it input, correct?
Yes.
And at the end of it, you left without her ruling it a homicide, correct?
Objection.
I have nothing further.
No, none, thank you.
All right, you're all set, Trooper.
Thank you.
So, jurors, this break we're going to take now.
We're taking a break now? No? What? What'd she say? She said we're taking a break?
All right, we're going to take a break. The lawyers and I have some work that we have to do, so it's a little bit longer break than we normally take, and it's a little bit earlier, but we did get coffee for you, so we'll take a recess now for the next half hour, maybe. I want counsel to stay.
All right, so the court, please.
Are they gonna let us hear what's going on? There's no way for us to know what that is. Everything's muted. Why don't they let us see this? I don't understand why we don't get to see any of this. This is one of the things that frustrates me about these. Like, why is this not an open court? Why can the public not be aware of what they're discussing here? It's very aggravating. It's very, very aggravating. I mean, I guess I'm playing a role more of a juror right now than anything else. Oh, wait, are we going somewhere?
Seated.
Oh, good. We are going to see it.
So I want to talk a little bit more about what we talked about at Sidebar. And I read the decision from Maryland, just cursory while we were waiting for the witness. And that was a March decision. And I can't stress enough that this should have been brought up before today. So I'll hear you about your concerns, Mr. Alessi. I'll hear the Commonwealth's response, then I'll go finish reading everything else you gave me. So what are your concerns about Jessica Hyde? I don't know if she's Dr. Hyde or what, but I remember she testified the last trial, so you have transcripts.
Understood, Your Honor. I first want to just get quickly the evidentiary basis. This is straightforward judicial notice. There are two separate decisions which require two separate.
One's a Massachusetts case, so that's easy enough.
Okay, so and that's a shell.
It's an SJC case, so yes.
Yes. Okay. So now to the Maryland case. So that's governed by federal, Massachusetts Rule 39A. And that is records of courts of other states or of the United States. The Act provision is the records and judicial proceedings, and of course, a court is judicial proceedings, of a court of another state or of the United States shall be competent evidence in this Commonwealth if authenticated by the attestation of the clerk or other officer who has charge of the records of such court under its seal. So I have with me, Your Honor, that State v. Herrera, Maryland case. I have the certified copy with me from the clerk.
All right, so we can mark that for identification.
Thank you, Your Honor. May I approach?
Yes.
CC for ID.
Okay, thank you.
So assuming Your Honor determines that the seal is the seal, it is a mandatory under the rule that it shall be competent evidence, it shall be in evidence. And to the extent the Commonwealth seeks to argue relevancy or materiality, that argument is precluded, Your Honor. In the best evidence of that preclusion is the immediate section below in Rule 39, which is notice of foreign law, which is not this, but it says there, the court shall upon request take judicial notice of the law of the United States or of any state, territory, dependency thereof, or of a foreign country, whenever it shall be material. So the drafters of this rule knew how to put in a qualification or condition when they introduced materiality in B, but they didn't do it in A.
Okay, so focus on what it is you think Jessica Hyde should be prohibited from testifying about.
Oh, Your Honor, I am not seeking to prohibit her from any testimony under this rule. What I want to do is to have it admitted in evidence, have it published, and question her on what she presented to the court in the Maryland case, what was presented, her report, because it was deemed not reliable. And that is what.
In one area, right? One specific area?
Well, you can call it one
The
area.
decision.
Right. Oh, yeah, just what's in the decision, but there's two parts to that decision, two areas. It's FLH, frequent location history.
Right.
But what the court also got at was Apple source codes, that she didn't have the Apple source code.
Nobody in the country has the Apple source codes, right?
Point exactly, Your Honor.
So what is it that, so you want to put in her report and question her about a proceeding in Maryland? I need to know exactly what you're asking
If I could
me
proceed
to allow.
give you the answer, Your Honor, I
Go
will
ahead.
explain it. It's a very short answer.
Okay.
What I want to do is with regard to her 227 timestamp and her anticipated testimony on that, where she uses a tool, Celebrite, to determine and come to a conclusion about that timestamp. She is not using Apple source code to find out where that's located specifically in the phone and what it means. She is using a surrogate to do that. And I want to cross-examine her on the topic using this decision to say, in Maryland, you tried to do the same thing with regard to FLH. You tried to use a surrogate approach and make an opinion about whether that is in fact what's in the phone. She can't do it, and that means her testimony on 227 is not reliable. I'm not looking to exclude it. I'm looking to cross her on her reliability for the conclusions I anticipate she's going to make on 227.
So if she is not asked about that, then what?
Oh, if she's not asked about the 227, and I want to think about it, but I'm 99% certain I am not going to pursue that at all.
Okay, what do you say, Mr. Brennan?
This is an attempt to try to malign a witness with something that's wholly unrelated and not relevant to what she's going to testify to or the basis for her opinion. It is not a law that is admissible. It's an opinion. It wasn't even about a specific case. It was about a peer review. And so in a Daubert hearing, the court did not allow testimony on significant location. That's not the case here. Try to conflate the argument saying it has something to do with Apple 227. There is absolutely no basis for that argument. They want to say that another court rejected something about you, therefore the jury should reject you. There is no relationship between what she is going to testify as a basis and that opinion. That opinion did not say she was wrong. It said that it was not admissible under Daubert, unrelated. Nobody has the Apple source code. No expert can testify about Apple source code. It's only owned by Apple. And so using the words like surrogate is a way to try to cheapen her testimony in front of the jury. This here, number one, what he said, I really can't follow him. I don't understand, other than he's trying to draw some type of relevance to materiality. There's none. There's none. This is not a denouncement. She hasn't been found incredible. There's nothing about her methodology that has been rejected by a court. This is on.
So apparently this doctor testified in another case and tried testifying, and they said that the method of testimony that she was employing there did not meet Daubert, and Daubert is the universal law across the country as far as when something can be deemed properly scientific. It's the test that's employed in order to establish that something can be considered science rather than just being junk that should not appear before a jury because it's more likely to confuse them than enlighten them. So apparently, because there's an issue with her ability to know what's in the source code of Apple, that which she was testifying about failed under the Daubert test. Unless he's saying that he wants to be able to bring that up in order to attack her credibility, even though it's on a different issue from here. But the fact that she basically failed to meet the Daubert standard in a different case, that's something he should be able to use to impugn her credibility. Hank Brennan is saying that's a completely different case. Who cares if she was debunked there? From what we've heard so far, I actually think Brennan has a stronger argument. But otherwise, unless he can't just cross-examine about something from a different case that has nothing to do with this, it has to be on point to what she's testifying about. That's why they're having this motion for this. They're having this application for the judge right now.
Significant location, and although she looked at it, that's not part of this opinion whatsoever. And so because another court didn't allow something under a Daubert, has nothing to do with this case. Nothing.
And what is it that you expect her to testify to, Mr. Brennan, regarding the 207 stamp? We did not have this issue with Mr. Whiffen, right? This was not raised with Mr. Whiffen.
Oh, it was. The 227 timestamp.
No, that was raised, but this.
This is about whether or not the search was how long to dying cold was actually done at 6 o'clock in the morning when, like Jen McCabe says, or like the timestamps indicate. I think it was 2:27 in the morning.
What was problematic in Maryland? The same thing that was problematic in Arrington.
That's correct, Your Honor. It wasn't raised because Mr. Whiffen has not been Daubertized with regard to Apple source codes. And if I could, Your Honor,
Okay.
Mr. Brennan has made a relevance argument. He keeps anticipating my cross, which he has incorrect, by saying it's not relevant. That doesn't go to the admissibility in my cross. I'm entitled to cross her on her reliability. And if I could, Your Honor, in the state Herrera decision, if Your Honor would look at page 3, please, at the bottom, the paragraph, it says, in assessing the reliability of an expert's methodology, I get to do that on cross. It's not limited to a Daubert hearing. Every expert can be crossed on their reliability of their methodology. And lastly,
he's expressing himself better now. His point is that when you're looking at the statute as to what he's allowed to cross on, what he's not allowed to cross on, so it doesn't have to be relevant to this particular hearing if I can establish it is relevant as to whether or not this woman is trustworthy. This witness is trustworthy. So that is something that I can cross her on. And it doesn't matter if her lack of trustworthiness arises from the stuff she's talking about today or in general, and I can attack her from outside of that. That's a stronger argument he's presenting.
With regard to the Apple
he said it
source
earlier,
code, if Your Honor would please turn to page 6, the last paragraph, it says the issue raised in this case stems from the fact that Apple's algorithms are proprietary and the expert did not have access. That's exactly the situation here and what I want to cross her on. So in conclusion, Your Honor, the fact that how she tried to get around the Apple source code, her methodology in the Herrera case, she got Daubertized on because it wasn't reliable. That's exactly what I want to cross her on, is her reliability, how she's trying to get around them in this case. It's just basic cross-examination.
He's making his argument stronger and stronger as he's going on here now. The same way her methodology didn't work in the other situation, in the other cases she was in, that he's basically arguing that why didn't it work? Because it wasn't deemed credible. She's employing a similar methodology over here, and the jury should interpret it as not being credible. even if the court wants to admit her testimony and say, we do think that this meets Daubert, at least the jury should be aware that not everyone agrees that this is satisfactory scientific evidence for a courtroom.
You can see the plan to dehumanize somebody, Daubertize,
Dehumanize.
to use a term to suggest some type of conclusion that has no basis in fact is an attempt to just dehumanize her and limit her testimony and credibility without any basis in fact.
Oh, the
In that
humanity.
case, it did not deal with the search of a tab and a suspended state in Safari. It didn't deal with the timestamp. It was an entirely different issue. By their analysis,
Really that
if a expert goes into court on a motion on anything to do with data forensics, and the court says that issue is not admissible, they should be impeached when they go and talk about a totally different issue in forensic data analysis at another case. They have not shown any evidence that this issue has anything to do with her effort in the timestamp. They just use the word methodology. Her methodology was questioned in an opinion in a different court. Has nothing to do with her opinions here. What information do they have that her methodology in this analysis has been rejected by any court? What evidence do they have that the methodology used in this case is unreliable or improper? They don't have any. In fact, they called an expert themselves in the last case who tried to provide what he believed to be methodology, and they presented that. They proffered that evidence as reliable. No different on this subject. Herrera case is a totally different subject.
Your Honor, first of all, as the court has noted, the first trial is the first trial. This is this trial. I wasn't at the first trial. The most important and probative aspect, Your Honor, is I don't want to have to give away my entire cross in this argument.
No one's asking you to. I'm not asking you to.
There is parts of Ms. Hyde's slide that go to location. There's a good part of her slide presentation. I don't want to depart from the 227, but the good part of her slide presentation that she's going to present is on location. It is with regard to health data steps. So there are certainly aspects directly relevant. Here's the issue with the 227 in addition. There is, for her methodology, she's claiming a certain conclusion and opinion about the 227. There is no peer review. There is no article that she can cite to support her methodology to come to the conclusion that the 227 timestamp, one, doesn't exist anymore, or two, doesn't mean that the search occurred at 227. That's what she's opined on in her report pre-trial, and that's what I anticipate she's going to opine on when she takes the stand. I'm entitled to cross her on that. We can't be saddled. It's irrelevant what our witnesses said in another proceeding. It's what this witness is going to talk about in this matter, and I'm entitled, and my client's entitled to have me confront this witness on what she's going to testify and her methodology. So my point is, Your Honor, this decision, how do you impeach an expert? That one of the fundamental ways you do it is, and I don't mean to
methodology.
I won't even use the term Galbertize anymore. She's been deemed unreliable. Attorneys who do experts all the time, that's the verb you use to shortcut it, but I won't use it. I have no intention to dehumanize her. What I intend to do is to impeach her on her reliability. So in conclusion, Your Honor, the Herrera case, she was deemed not reliable. That's competency. You, and any expert that's been deemed that, you get to attack that. If the Commonwealth believes the case is not relevant, if Ms. Hyde believes it's not relevant, let Ms. Hyde defend that on the stand. Let Mr. Brennan make that point on redirect. But I can't have my client's constitutional right to confront her on the very subject matter she's going to testify on by anticipating what I'm going to provide for cross. I've given it, and I respectfully submit, Your Honor, this is basic cross of an expert witness, particularly when their methodology on data forensics has been deemed not reliable by a court. And one part is the location. She has in her PowerPoint, she's going to testify.
Do you intend to introduce that, Mr. Brennan?
It's not significant locations. There are locations in the database that develop the opinion that the timestamp for 227 is not related to the search. They're conflating the issue. She has not been deemed unreliable. It is the issue of the significant locations by that court that they found insufficient. There's no opinion opinion from a court that she's an unreliable expert. And this is how they're going to distort it. Invoking the Constitution and invoking the client's rights has nothing to do with the analysis. That is a totally separate subject, or an opinion simply wasn't let in a different court out of this jurisdiction. It wasn't this opinion, it wasn't this methodology for the opinions that she's going to offer in this case. And so if you look at the case, it is
I'm just going to say both of these attorneys are smart attorneys. You can love them, you can love one and hate the other. I'll tell you right now, they both are good at what they're doing. They're presenting their arguments very powerfully. This is a tough call.
Totally different related report, different related.
I would err
item.
towards letting it
It's
in.
as if a reconstruction expert went into a court and attempted to give an opinion about a medical diagnosis, and the court wouldn't allow that medical diagnosis in. In another court, in another jurisdiction, they would not be able to be cross-examined that in some court, there was an opinion they offered that was deemed inadmissible, unless they were talking about the very same methodology and the very same point. This has nothing to do with her opinion whatsoever. It's just an attempt to try to endorse the defense's attempt to suggest she's not credible by hiding behind the shield of a different judge and distorting the fact that it's two different methodologies, it's two different issues.
One last word. Go ahead.
Thank you, Your Honor. He just said credibility. This isn't a credibility issue. This is a reliability. This is the essence of what experts do. You have to show that your methodology is reliable. It's a red herring to bring up credibility. The court opinion.
And this is the equivalent of a Superior Court opinion, right? It's not an appellate decision.
It is, Your Honor. It is the equivalent. I respectfully don't think that the level of the court is at all relevant. Any court, unless you get it overturned on appeal, then this would be a different matter. But this is the.
I like the way he slid in here. Make it overturned on appeal.
And even if it wasn't, it shall be in evidence. So there's two issues here. And I think the Commonwealth is conflating that. The question first for the court is this admissible? Can it come into evidence? To me, that's a non-issue. Rule 39 says ipso facto, yes, as long as I've got a certified copy. So it is in evidence. I don't know why we're perseverating respectfully on whether I can question her on something that's going to be in evidence about her. Final point, Mr. Brennan incorrectly says that this wasn't about her. The final sentence, the decretal section on page 7 says, accordingly, defendant's motion to exclude expert testimony regarding the significant location data obtained from the forensic cell extraction is granted. She's the only expert, and her name is mentioned throughout this opinion. It's all about Ms. Hyde. And I'll conclude my last point, Your Honor, where I started, and that is Ms. Hyde's methodology. With regard to her PowerPoint, you heard Mr. Brennan's answer. He is going to include, he has included in her PowerPoint locations, steps, etc. It's exactly what was at issue here. The 227 timestamp, she has no, and this will be developed further on cross, she has no peer-reviewed article to say that how she is determining that 227 timestamp should not be in the data. She has nothing to support that, just like she had nothing in this case with regard to data forensics. Final point is, if the Commonwealth believes that this is irrelevant to what Ms. Hyde did, let them come back on redirect on that. I shouldn't anticipatory have my cross-examination struck before I even get to pursue that with the witness. And I believe once I pursue it with the witness, it will become evidently clear that it's a proper basis for cross-examination.
He baked in there a phenomenal point that I think he could have hit on a little bit harder. But he basically baked it enough that I was able to draw it out, and the judge should be able to draw it out also, you would hope. Under the rules of Massachusetts rules of under the Massachusetts rules of evidence, apparently it's Rule 39, he has a right to submit this other finding about this expert, that other hearing, as long as he presents a certified copy from that other case, which he has done. So now, and the court cannot reject that evidence. It has to be accepted. If you think for a second, why would the court why would the rules of the court require this court to accept that evidence and then stop him from being able to ask questions about it? That makes no sense. Clearly, the reason why the rules of evidence, as passed by the Massachusetts legislature, dictate to this court that they have to allow that certified copy in and be presented before the jury. What's the jury supposed to do with it unless he asks questions? Unless he's able to ask questions to this witness related to that certified report that just came in. So clearly, the legislature has directed the court that he's allowed to ask these questions that relate to that report that the legislature mandates must be admitted by the courts. That to me, when they started their argument, I was like, I'm kind of leaning towards Brennan. He just won it right there. He also was claiming that the methodologies that was employed, that was rejected in the past, is similar methodology and not peer reviewed and has always different problems with it. But that was, he really went, and they both fought like really excellent advocates for each of their sides. I know a lot of you don't like Hank Brennan, but I'll tell you right now, he presented his arguments very, very well. He's a good lawyer, Brennan. I don't say that about a lot of prosecutors, but he's a good lawyer. He is. And he presented his argument well. You can hate his voice, you can hate his accent, whatever. You can hate what he's standing up for. But he did his advocacy very effectively, but Alessi just beat him, in my opinion.
All right. And Mr. Alessi, have you thought about, if the Commonwealth does not get into the 227 timestamp, whether you think you're still entitled to do this?
Your answer, Your Honor, my answer is I would be entitled, but I would say this: if they don't get into 227, I won't go after it. I won't pursue it. I won't pursue use of this opinion.
We necessarily would have to on some basis, because in order for the witness to explain to the jury her opinion that Ms. McCabe did not delete any Safari browser searches, she would have to identify the search, where it is in the databases, and how she can tell, how she knows that it wasn't deleted by a user. The same with the second part of the phone calls. But if I could avoid talking about 227, I would, but it is necessary for the basis of her opinion. There's just no way around it. And again, this is something that after a defendant expert may or may not testify, could be addressed at that point. There is no burden on the defendant. I'm not being presumptuous, although there was a offer of proof earlier on similar evidence, but not knowing the court's wisdom on whether I'll be entitled to rebuttal, I do not want to lose the opportunity to address points that were made in the opening that have absolutely no basis in fact and have not been proven in any way to this point in the case.
So I asked earlier whether the defense intended to call Mr. Green, and you believe that you do, right?
Your Honor, we have not made a decision on what data forensics expert we're going to call, but if I could just 10 seconds.
Okay, but then answer my question after your 10 seconds.
The judge is trying to punt. She's trying to punt and say, well, if I keep it out, you can bring on your own witness to rebut. That's not good enough to turn this into a battle of witness. That's a cop-out. That's because they have to be able to attack the credibility or reliability of the testimony that's being presented in here. Not feel like, well, now we got to get this person in here and hope that the jury's going to believe our guy more than theirs. That's ridiculous. It should not be relevant to her calculus of determining this question. I don't like that call at all.
I will. Mr. Brennan can't have it both ways. He can't say, yes, I need to address the 227 timestamp, and then deny me the ability to cross-examine fully on this expert's methodology and to impeach her and to get at her reliability and her competence, which is a key issue of crossing an expert. Her competence has been determined in this decision, and it is her, because it was her report that was the basis for the court to not allow her to testify. They can't have it both ways. You can't say, I need to do it in direct, but no, I want to handcuff the defense on cross-examination. Now to answer your question, Your Honor, we are going to have a witness that is going to address the 227 issue. Whether it's Mr. Green or somebody else, we haven't determined. My point on that, Your Honor, is we shouldn't be limited in our cross-examination of the Commonwealth.
No, I'm just thinking it in terms of whether this might be appropriate for rebuttal. That's.
Yeah. And Your Honor, my point would be that's obviously going to be Your Honor's decision ultimately. But again, the Commonwealth can't have it both ways. They're the ones who are triggering this issue, and I say triggering in a legal sense. They are putting at issue the 227 timestamp with this issue, with this witness. If they weren't doing that, I wouldn't be having this discussion at all. But they're putting it at issue. I have the right, respectfully, to cross-examine on the issue that they're putting in issue, and they shouldn't get rewarded with sort of having a pre-authorization of rebuttal to deal with it. They should have to meet their burden of rebuttal depending upon when the evidence comes. But I don't believe just because we may call a witness, that should dilute my ability to cross-examine this.
That's what I just said.
Witness
Shouldn't.
on an issue they're raising. I'm not raising it.
You can see why I wish I had more notice on this, right?
Your Honor, I have no good answer for that.
So I will do what I can in the next half hour. I might need more time on this, frankly, but we'll see. She's here.
Your Honor, may I ask one thing? May I, Mr. Gray?
I just want to know, is she here?
Yes, Your Honor.
Can she stay another day if need be?
I think she'll do what the court directs her to do. She would have to leave by Friday. She cannot be here. Well, may I approach?
Yeah, why don't you come up?
So that doesn't need to be on the public record. Her personal schedule, that I'm fine with them having at sidebar. That was a great argument. That's a sort of fun argument. And this is why I was saying I really enjoy watching trials between good attorney when you have good attorneys at both sides, irrespective of who you may internally be rooting for. You get a much better examination as to how the law should operate. And it's fun to watch a couple of, the closer they are to being titans, the better. You're watching, to watch the best go at it, rather than one person who's kind of outmatched by the others, or a couple of idiots slapping at each other. That was great. That was a great legal argument by both sides. So I need to be my family. And this trial just isn't doing it. It just isn't. I'm really enjoying it, but I can't do this as a hobby. For one reason or another, it doesn't seem as if my audience seems, I have the same people coming back, and I love you guys for coming here every day. I really do. But just the numbers on the views and stuff like that, it just doesn't, and the exposure to new audience just isn't happening here. So I got to feed my family. So, and the Diddy trial, I think, has potential to give me far greater exposure. But I'm enjoying this. And I'll tell you something else. The Diddy trial will also, I know both sides. The attorneys on both sides are phenomenal. I watched Maureen Comey, on the prosecutor's side. It's the same team that went after Ghislaine Maxwell. And that team is excellent for the prosecution, the ones going after Diddy. I don't know everyone on the Diddy defense side, but I know one of them is Brian Steele. Brian Steele is a phenomenal attorney who has showed brass cojones in exposing Judge Glanville. So, in the YSL Young Thug case, and standing up and going to prison. I think we're on our 15-minute break now. And going and willing to spend, not go to prison, put himself and his loss license and willing to get sanctioned by the judge for calling out the judge's blatant abuse of his position, and ultimately seeing Judge Glanville get removed from that case altogether. That was Brian Steele, and for the defendants in the Young Thug case down in Georgia, and he's one of the lawyers defending Diddy here. So I know that I'm going to be watching a battle of titans in the Diddy trial, and I'll be able to help break it down in ways that I don't think anyone else covering it is going to break it down. In fact, I'll go one step further. I know that when I'm breaking it down, it's going to be in ways that no one else is breaking it down, because I saw how coverage works on these things. They'll give you the ins and outs, the legal arguments and stuff like that. No one else. So One thing that did come up there that's really interesting that they're expecting this Ms. Hyde to testify about is the notion that she believes she can establish that Jen McCabe is not the person who deleted that search. The deletion of the search does feel like a damning reflection of a guilty conscience. And that's why she would delete it. Why are you getting rid of something that you did that was nothing, there was nothing wrong with it? So apparently this Ms. Hyde is going to come in here, or Dr. Hyde, whatever she is. I'm not sure if she's a doctor or not, but she's going to come in and try and provide expert testimony that through her methodology, she establishes that Jen McCabe did not delete it. It got deleted in a different way. So that could help, perhaps, to the extent some jurors have concern with her. Let's see. That could certainly help in that regard. But yeah, okay. When there's one person providing those tweets, which is Inner City Press, Matthew Lee, who I've met, I know, we know each other. I've sat next to him in trial, tweeting the same time as he does. What I find when I tweet out and he's tweeting out at the same time is that we have an overlap of like roughly 20%. Because he'll focus on some things and I'm focusing on something else. We're both trying to focus on what we think is most important. And that's not at all a knock on Matthew Lee, who's phenomenal, and everyone should follow that guy because he's a smart guy. He's also an attorney. He's just sharing with you his thoughts as to what's important in the trial. You cannot get everything down. It all happens too fast. And there's a lot of important things that happen. And to one person, something will resonate as being more significant than to another person. Frankly, you need 5 Matthew Lees there. And if I'm there, there'll be 2. Maybe Adam Klarsfeld. Adam Klarsfeld tends to have a more leftist type of lean to him. But yeah, so you really need 5 to get like some sort of real coverage. You're just getting a taste when you have one person there. So I don't know if I'll be able to live tweet the first week. I doubt I will be able to, because I don't expect that they're going to let me have my phone in there, certainly before I have an updated journal pass. I don't know if I'll be able to get my phone in there. I'm skeptical that I will, because I've gone through, when I've gone through federal court, I go through their detectives, they take away all my stuff. But we'll see. We'll see. I was in the middle of referring back to Pinochet, who earlier made a comment, and I wanted to come back to it when we were talking about Pam Bondi, saying, Joe, how did Gideon pick his soldiers? Because we had been talking, if you came late, we've been talking about how Pam Bondi, there's exposure coming out now that she has ties to Pfizer, or that she got money from Pfizer last year, and people are using that as an indictment of her character, or the reason, or the sign that she's duplicitous, or that she's in league with the neocons, and that and with the establishment, and that she's not going to be properly prosecuting. And I said, it could be. It's a reason I have concerns. But we don't know that about her individually. So Pinochet said, Joe, how did Gideon pick his soldiers? Not the ones who were naive and lapped at the river like dogs, but the ones who kept their hands on spears and their eyes on the horizon towards the enemy. It's interesting that that's how you learn that, that's where your training in the story of Gideon goes to. When I learned the story of Gideon, meaning, and I assume that you learned that in Christian teaching, and it's an interesting way of looking at that story. When we learned that story, we learned that the flaw in the soldiers in that story of Gideon is that they were kneeling down and basically didn't have sufficient reverence for God. that they were willing to kneel down before this river for purposes of drinking. But it reflected something about their character. It wasn't as far as their military preparedness or the constant alertness. It was a matter of the ones who got down on the ground to cup the water to their mouths, refused to in any way bend to idol worship. It was that type of, that's what they were reflecting by their posture. Although I guess even the way that we learned that story, you want to bring that back here to Bondi, you can say the fact that she's willing to take money from Pfizer is bending to the elites. So while the way we learn the story is somewhat different, either way you learn it, you could bring that story back home and apply it to Bondi as far as not loving her as a selection, but she is what we have now. So you sort of you have to go with what we got and hope for the best while being alert for the worst. Freedom Forever says, Robert and friends, my husband passed away on May the 4th. Be with you, Day. Sorry. I'm so sorry. Nice. Sunday, 6 May 25. Well, he will have full military honors or in for the following fundraisers our son is setting up. Yeah, my deepest condolences. I'm terribly, terribly sorry. Being a veteran is all may God bless his soul and bring you and your family inner peace and condolence. Cat's butt. Thanks, Joe. Cheerios are on the dinner menu, but I can't afford the milk. Oh my God, I gotta hit the horn for him. He dropped me 100. In Rumble, thank you very, very much, Cat's butt. Cheerios are on the dinner menu, but I can't afford the milk. Well, I appreciate you affording that very generous rant. Thank you, brother. Phoenix says, I, Christian, I learned this story in the Army. I know human nature. It's not the ideal we want it to be, but it's how the world is. We say justice is blind. She is not. Justice in the U.S. is a lie. And like I said, I too study human nature. There's few things I've studied in my life as much as I've studied human nature. I'm fascinated by human nature. I never want to ignore human nature. And as a default, I tend to assume that human nature will win out. Especially when you talk about, and that should give us grave concerns in areas where human nature tends towards the vices, as I said, of vanity, power, fame, money. So they tend to will out. And when you see someone shows that they have an appetite for money, so that's usually who they are. However, when she took money from Pfizer in the past, it wasn't through corruption. Presumably, she was hired to represent them in certain matters, and they gave her a nice check. But the matters that she was representing them in could have been completely innocuous and nothing nefarious. It's not like everything Pfizer ever did was, they're not a satanic entity here, that everything they touch is rooted in harming the public. So it could be that she took it to do good things. I don't know. I can be hopeful with it while at the same time having my eyes half open, half closed. There's an ancient Chinese saying which says that before marriage you should have your eyes completely open. After marriage you should have your eyes half closed. Not fully closed, but half closed. We are now proverbially married. Our justice is now married to the integrity of Pam Bondi for the foreseeable future. So we should have our eyes half closed. Not just blindly accepting everything she says, being alert to certain problems, but not freaking out. Half closed. Not freaking out every 10 seconds. Just say. And your eyes should be perhaps a little bit more, our eyes should be a little bit more open once we see various connections that she's established, which would give us pause if we were to be bringing her back, deciding whether or not to bring her in today. That's all I'm saying on that. That's all I'm saying on that. I didn't mean to get into a whole Pam Bondi thing today. Somehow we found ourselves there. But yeah, this trial is fun. I really enjoy watching good lawyers do good lawyering. I think in the end of the day, Alessi really won me over though with that point that he made there. In case you just joined, we were bearing witness to a legal argument that was being presented between the state and defense as to whether or not the defense would be allowed to cross an expert witness that the state is about to bring in, if not later today, then by tomorrow, seemingly tomorrow, because the judge seems like she wants to think about this whole issue. The objective of this witness is to come in and testify regarding Jen McCabe's phone. Specifically, one of the things we expect that she's going to be testifying about, the state wants her to testify about, is a 227 search, how long to die in the cold. It's showing in the records as being done at 227. We've seen testimony that's been designed to show that she opened the tab at 227 and later on used that same tab at 6 in the morning, that would show a timestamp at 227. That search was deleted, which shows some sort of consciousness of guilt that she did something wrong and trying to hide it. This witness is supposed to come in and testify that, in their expert opinion, the deletion was not done by Jen McCabe herself, but by some other third party. I don't know how we're going to know that. And also something potentially about the 227 time. And Alessi, for the defense, got up there and argued her methodology in a different case in Massachusetts was rejected. We believe she's using similar methodology here, or similarly flawed methodology here. We want to raise this issue as to how her methodology was rejected in a different trial because it's not sufficiently scientific. There's a rule called the Daubert rule, which establishes what yardsticks you need to meet in order for something to be deemed actual science in a courtroom, rather than someone coming in there and saying and presenting things that the law does not recognize as having sufficient credibility as to be deemed scientific, that will allow you to get up there and espouse that this is what science says. So that Daubert rule is what is from a Supreme Court case, which is now has set the yardstick for the entire country as to what standards you need to reach in order to reach Daubert and be deemed credible scientific evidence, and if not, it should be rejected by the court. So they actually use the term Daubertized for someone who doesn't meet that standard. So Alessi said that under the rules of the state of Massachusetts, if she's been rejected over here on something that's similar methodology, I can establish and I can give a certified copy of that to the court, and the court must take it as evidence. And just as you must take it as evidence, I need to be able to cross-examine her and ask her about that to try and establish that the same way it wasn't scientific there, this different methodology using that's very similar is equally should not be relied upon by this jury as being compelling evidence of anything. It's not been her methodology has not been peer reviewed. She doesn't have the source code for what's happening, how Apple created their stuff. You're claiming you know how this whole Apple system works together with Safari. Your methodology has not been recognized by anyone in the scientific community. And you're just throwing this out here as to what you think is accurate. And here's this other report which was rejected. Brennan, for the prosecution, came back and said, you're just trying to malign her by saying you didn't reach a yardstick in that other case, so now we can't trust you anything anywhere, when this is a whole different methodology. She's employing a whole different methodology here, and you want to try and basically try and embarrass her and make her seem as if she's an idiot with evidence that's got nothing to do with this case. You're even referring to doubt. You want to dehumanize her, you refer to it by Daubertizing her. It was there were well-proffered arguments for both sides. The judge wants to sit on it. So there we go. In case you wonder what's happening in the courtroom, this is where we're at right now. That's what we got going on. Let's make sure we're live. Yeah, live. Okay. They took an early break, but you don't need fan stream. Welcome aboard, Pro Gamer. What do we got here? Penis says, far too dangerous to give the benefit of the doubt and hope is not a strategy. I don't know what you want for strategy. What are you advocating for? You want to sit there yelling, get rid of her, fire her, fire her, fire her? You want to tell me that your leash is going to be shorter with her? Okay. But tell me that your leash has already been timed out 106 days into this administration. It's your prerogative. But now what? What does that do now? So you want to go on a I hate Pam Bondi crusade? We can do that. And try and convince people to take up arms in that. But I'm not there yet. I really appreciate this. It's very kind of you. Do duty in the morning and read updates in the evening. Don't deprive us of your inside response as a first-time trial viewer on read. I'll have to see. I don't know how I would absorb all the things that are happening in the Reed trial to give you any kind of meaningful input. I'm sitting here for 7 hours a day watching the Reed trial. I have a real handle as to what's going on inside this courtroom. When I'm sitting there as someone who's spending 7 hours in a different courtroom, it doesn't make sense to go to duty in the morning and then miss the afternoon. That doesn't make any sense. You can't. There's a phrase we have in the old country, which is you can't dance at two weddings. You cannot dance at two weddings. Doesn't work. That's what we have in the old country. So variance. It's madness that Bev keeps searching for a way to deny Karen a right to fair trial. I don't think that his argument was trash. I really don't. And you can, I mean, that's just my opinion. I don't think his argument was trash. I think his argument was you're just trying to malign her so what she can never testify again. Every time she testifies, no matter what she testifies on, we're just going to assume that her testimony, because one time a court said, no, we're not accepting it, that for the rest of her life, every time she goes anywhere, whatever testimony this expert witness gives must be trash, and she has to be dulled for that. That doesn't seem, that seems very harsh. So the judge seemed confused about that also. She's like, I don't know if she's a doctor or not. Judge seemed very confused about it. While you're here, if you can like and subscribe, I would be much obliged. I need to have that little cartoon thing running a lot more. They say I don't do it enough. That's what they say. Just but I need to do a local stream. I need to. What should I do with locals? What should I do with locals? If you're not signed up on goodlogic.locals.com, that's goodlogic.locals.com, which is where I have added bonus content that I put in there. It also is where you get notifications. You can go there and sign up for free at goodlogic.locals.com. The added bonus content is a minimal cover charge, which is a recommended fee, well, $5 a month, where I try to provide additional bonus content, and I feel as if I've been depriving my audience there. This trial has just been knocking me out. But it's a lot. It's a lot of time and effort. I was watching a video this morning, completely off topic from Karen Reed for a moment. I was watching a video this morning about the Dunning-Kruger effect and why it's so prevalent. And so I was like, while I was getting dressed this morning, I was watching this and I was like, there's some interesting points here, which is very relevant in this post-truth world of ours. I was thinking it'd probably be a good locals topic. Sherry, I'm not. That was my point. My point is I'm gonna have to basically jump ship here. And that's why I've been giving everyone a heads up that is what's going to happen next week. That I'm going to be at the Diddy trial. They're doing jury selection this week. They're supposed to be finished with jury selection and have opening statements on Monday. And that is going to be in Lower Manhattan. I live in Northern Jersey. And it's like an hour and 15 minutes to get there. From door to door. It's like an hour and 15 minutes. So I was watching Robert Gouveia last night. It was funny when he was covering some of the things related to Inner City Press's thread going through jury selection on Diddy. This shows you how significant the Diddy trial is. It was almost like, and I asked Robert Gouveia this question. I asked him, should I stay with Reed or should I switch over to Diddy? I asked him this very question because Robert Gouveia is a friend of mine. He's been kind of a mentor of mine going back to my earliest days, and I was like, what should I do here with this? And he told me, go do Diddy, you'll kill it. And so that's what he thinks. Go do Diddy, and you'll kill it. And that this, he said, Karen Reed is too saturated. Diddy is not at all. You have unique access. Go in there and kill it, and you will. So, and I take his advice very, very seriously. It was not like my own unilateral decision. This is like, I mean, it is ultimately my decision, and I accept responsibility for that decision, for better or for worse. And frankly, I'm really being guided by God. I just sort of like weigh it all in, and then God's going to sort of, I hope, lead me. It doesn't mean it's going to be more profitable. It just means that like this feels like what I'm supposed to be doing, and it's after carefully weighing all the options. And I don't look at this as, I'm not complaining about it. They're both potential blessings from the perspective of my job here. But I'm covering the Reed trial, which is fun and entertaining and could potentially be financially rewarding for me personally, or Diddy, which is much less fun, but could be potentially rewarding. So they're both, thank God for both opportunities. So because I'm situated here, I have to at least ask myself the question. And when I asked that question to myself, my gut was leaning towards Diddy, and everyone I've spoken to was like, you got to do it. So even though it's a lot harder work. It's a lot harder than this. This is tiring. That is like exhausting. I know I'm going to be beaten down by that trial. So Diddy will be oversaturated when it actually starts, but it's not going to be with people in the LawTube adjacent community, because there's only so many of us which have access. So I'm the only one here in what's considered the LawTube genre who's going to be there. Everyone else who's watching it is going to be legacy media, maybe a couple of independent people that I've never heard of, and that most of you probably never heard of. But for the most part, I'm going to be the only one there. So, and over here, with the oversaturation, I'm late to the party. So I feel like a lot of people, when they started watching Reed last year, that became their go-to on Karen Reed. So they're not going to switch out of that. They're unlikely to switch out of that. I can understand that. So I was trying to share with you. I want to share. This is a good opportunity for me to share with you. I tried sharing one video, but I want to share a different video. This is what I do. I basically sit there. Notes. I just ordered, and I'm supposed to be coming today, 12 legal pads, because they won't let me bring a phone in there or anything in there. I know that Matthew Lee has a setup. That's what he does all day long, every day, is a setup with the courts, that he's able to have phones. Some people are able to get it in there. I cannot. Maybe that'll change if and when my journalist badge gets renewed. But I don't expect to have that. So I expect to be handwriting a ton of notes. And then I come out during lunch break and I give you an update. I may create a video and drop that video probably like 1:30 or so, which will basically break down what I saw during the morning. Then I go back then I grab a quick bite, go back for the afternoon session, more notes. And then I drop an afternoon video. I'll show you with, I'll show you what I. All right. We came out of an early lunch. Man, I look so raw. I'm watching this. I'm like, I have so much less polish back then. It's 3 years ago. It's probably a better one. I'm trying to find the one with. It's not Annie Farmer's before Annie Farmer. This is the one I wanted. Let me share this with you. I just watched the most riveting, dramatic testimony that I've seen in my life. Arguably, real life or on TV. And I feel awful that none of you will ever be able to see it. This was compelling. It was dramatic. It was emotional. I mean, I it was I didn't mean to have that up there. So credible. And yet, well, let me set the scene for you, okay? This morning, the prosecution introduced the jury to Carolyn. That's her real first name. She describes the most awful circumstances of life that anyone can possibly imagine, even before she met Epstein. She has a mother who's an alcoholic and using drugs. She was abused by her grandfather from the time she's 4 years old, in the most awful way that a woman can possibly be abused. And then she's introduced as a teenager, a young teenager, barely past 12, to Jeffrey Epstein through Virginia Roberts, and how she suffered through this abuse for years as a minor until she was tossed aside at the age of 18 because she was too old for his tastes. She describes how she would use the money that she got from Epstein to buy more drugs. And the story, look, I'll detail it tonight in my breakdown, my detailed breakdown on my live stream at 10 p.m. But her direct testimony was only an hour long, and yet she was on cross-examination for 4.5 hours by Mr. Paliuka for the defense. And he kept bringing up all these different things to refute her testimony. She filed a lawsuit in 2008 and 2009, 2 different lawsuits against Jeffrey Epstein and his then assistant Sarah Kellen, and did not name Ghislaine Maxwell. None of those papers were naming Ghislaine Maxwell. She also she received as a result of that something like $450,000. And then when the Epstein Victim Fund was opened up in 2019, she applied again there, and she was awarded something on the order of an additional $2.8 million. And what he's doing is he's bringing up all these different factors and contradictions where she omitted talking about Maxwell and the first actions that she brought 12, 13 years ago, that she never points the finger at Maxwell, that there's inconsistent statements that she makes to the FBI as to the level of abuse that she sustained, whether there was, actual completion of events or whether she was just being fondled. There was just all these. I'll just share with you, by the way, it was 4.5 hours. Most of the time when she was shown contradictory stuff, she's like, I don't know. I don't remember. I don't know. I don't remember. I don't know. I don't remember. Where she looked pathetic. She looked absolutely pathetic. The defense counsel was destroying her. You're making all these claims today. You didn't make these claims 3 years ago. You didn't make these claims 2 years ago. When you brought up, you didn't bring it up in this situation. Why didn't you come up there? I don't know. I don't know. Like, she's crying. And she's like, I don't know. I don't remember. I don't remember when that happened. I don't know. Different contradictions. And every time she's like, she seems confused and she doesn't understand. Like, she's literally confused. I mean, I think that she seems to be of, and I'm not saying this in a judgmental way, she seems to be of limited intellect. And she's confused by what's going on as he's asking her questions like, why is it that you didn't bring up Ghislaine in 2008? So she would give an answer which made sense, an answer like that was a different case. That was a different case. And when he kept methodically going statement by statement through dozens and dozens of different statements that would show contradictions to the direct testimony that she provided today in court. And the whole time she's like, I don't understand why you're asking me this. That has nothing to do with this case. And she's not understanding how obviously what he's getting at is the contradictions in her story. She just doesn't understand it. And she's getting more and more agitated and upset. And certain times, he would ask her a question and she would start barking about how her life has been ruined because of Ghislaine Maxwell. And you could see the frustration and the lack of understanding as to what's happening in this trial. And that she's so hurt and angry and frustrated and lost, like literally lost. And and he's basically accusing her of either not remembering or lying or constantly changing her story depending on the circumstances. And he was making some serious headway. As far as look, in statements she made to the FBI where she describes penetration, which is what she said did not happen. And she even says that never happened. And he's like, well, here's your statement, which you said it did happen. Here's your sworn affidavit. Here's your interrogatories, constantly contradicting one thing after another. It was awful. And she's getting angry and she's like, I don't understand. Why is this? What does this have to do with anything? She's so lost and she's so confused. And then after 4.5 hours of this, where her credibility is really shot pretty badly, just been pounded to a pulp, Maureen Comey, who handled direct, gets up on redirect, and she starts firing off rapid fire questions at Carolyn. And she just jumps in there and and raising the different elements that have been raised, the different forms of documents that have been thrown against her. And she said to her, did you write the complaint that was filed in 2008? And she screams, no. She said, did you write the complaint that was filed for the Epstein Victim Fund? She screams out, no. And she says, did you review the FBI statements at any time prior to today? And she screams out, no. And she starts crying. It's like she's crying and she's screaming out, no. It was gut-wrenching. And she's like, did Epstein touch you when you were 15 years old? And she screams out, yes. And she's like, what year was that? And she's like, I don't know. She said, did she touch you when you were 14? And she's like, yes. And she screams, what year was that? And she's like, I don't know. And she screams, what did Epstein touch you when you were 13 years old? And she's like, yes. And she's like, and Maureen asks, what year was that? And she's like, I don't know. And I mean, it was just, and then she's like, why are you here today? And she starts erupting in tears about how, this woman ruined her life, destroyed her life, and that she can never get any sort of money. There's no way to fix this. And this is awful. And this is terrible. And there's nothing that can, and all of a sudden we hear objection from the defense. And she gets stopped by the judge. He says, I'm sorry, I have to take this objection. And he says, look, this is narrative. She can't go on like this. And the judge.
You have joined the meeting as an attendee and will be muted throughout the meeting.
Please be seated, court is in session.
The host would like you to unmute your microphone. You can.
That's
all right. I appreciate the time. I appreciate people's patience. So in reviewing the rules, I look at Rule 2. So Mass Rule of Criminal Procedure, Rule 2, purpose and construction. And so upon reflection and consideration, it says these rules are intended to provide for the just determination of every criminal proceeding. They shall be construed to secure simplicity in procedure, fairness in administration, and the elimination of expense and delay. Also looking to Commonwealth versus Durand. I don't have the site. I know it's from 2016, 2017. A judge, Robert Kane, was the trial judge. So because none of the purposes here in Rule 2 are served by the admission of the Maryland trial judge's decision, particularly where offered without notice to the court previously. I'm excluding that decision. Your rights are saved, Mr. Alessi. We've got that decision marked for identification, and you certainly are free to cross-examine Ms. Hyde regarding her methodology. So that's my decision. So bring the jurors in, please.
I didn't expect that. I didn't expect
You are
that.
unmuted.
That
Chris,
could
did
be
you want this
reversible
under
error
that?
right there. So she's keeping it out. She's keeping it out. Wow. Wow. Didn't expect that. Anyway. So the reason I was showing you that was that's a surprise. I'm surprised. I'm surprised she's keeping out that evidence. She's not letting in the evidence, and then she basically came to the conclusion that she's not going to that they're not going to be able to ask that line of questioning about what happened in the other trial. So it's bad for the defense. It means that she's not going to be able to be cross-examined about whether or not she is, whether or not her methodology is something that the jury can rely on, based on the fact that it has that similar methodology that she employed, that based on the fact it's not peer-reviewed, she doesn't have access to the source code, and most specifically, that part she can be asked about. That part she can be asked about to attack her credibility, but to invoke the other proceeding where those were bases for her to be rejected.
Jurors, I appreciate your patience. So your next witness, Mr. Brennan.
Anyway, I'm just going to say, so that's the sort of thing that breakdown that I don't think anyone else is going to be providing on the Diddy trial. And that's a breakdown I was doing 3 years ago when I was just starting out and doing this. I believe I've developed a great deal more polish since then, where I can present it even with, I mean, back then, in that particular video, I was, you could see I was feeling the emotion. But even hearing it now, I was feeling emotional. But they're not all going to be like that. But I think that's perspectives that no one else is going to be offering. And I think it's important. So, yeah.
Someone calls Jessica Hyde.
Jessica Hyde.
Follow me, please. Raise your right hand.
You solemnly swear the evidence given to the court and jury in the case now and here the truth, the whole truth, and nothing but the truth, so help me God.
Yes, I do.
Oh my, look at this one.
Good morning. Good morning, Your Honor.
What is that?
All right,
What the
Mr.
hell
Brennan,
is
whenever
that?
you're ready.
Thank you.
What
Good
is
afternoon.
Good afternoon.
Could you please introduce yourself to the jury and spell your last name for the record?
My name is Jessica Hyde, Jessica space HYDE.
Defense? Don't worry. When the expert comes in wearing this kind of turban, don't worry.
What do you do for a living?
I'm a digital forensics examiner. I'm also an associate. I'm also an adjunct professor at George
I was
Mason
thinking.
University, where I teach mobile device forensics in their graduate program. I also own a digital forensics company that does
Oh, this is
training,
gonna be good.
services, and research.
In addition to teaching at Georgetown University, do you teach in other ways?
Correction, I teach at George Mason University,
I'm
not
sorry.
Georgetown. But thank you. I also teach, my company writes and develops training courses. I teach a mobile forensic analysis course and a data structures course there to law enforcement, civilians, et cetera.
Do you engage in any other type of academics or research?
I do other research as part of some volunteer activities I do in the digital forensics field. So I'm the chair of DFIR Review, which is a body that reviews practitioner-created research so that it can go through peer review. I often do reviews as a member of a reviewer for Forensic Science International Digital Investigations Journal, which I was a previous associate editor of.
What does peer
Oh, I'm
review,
so sorry.
what does
This is
peer
gonna be good.
review mean?
Peer review means that when a study is done or a research paper is done on a topic, that an assessment is done of it. There are 3 types of assessments that can be done. One is a methodological assessment, where you read through the methodology of the academic or practitioner-created paper and state if it is acceptable or not. The second is you conduct your own testing using the same methodology to conduct a peer review with your own generated data sets. And the third is if the original author has shared their data sets, reviewing their data sets and checking that against their work.
Has any of your work been peer reviewed in the past?
I've had 2 peer-reviewed journals. I've had an article that was peer-reviewed and published in Forensic Science International Digital Investigations regarding the standardization of file classification of recovered items. The layman's term of that would be talking about what deleted means. And then I have another paper that's been accepted that I was a co-author on in terms of timelines and correlations of forensic evidence.
You mentioned you work in forensic data analysis. Generally, what does that mean?
It means that I look at evidence of digital forensics devices, be them mobile phones, computers, Internet of Things devices, and do analysis to provide meaning and context to the data that's recovered from them, as well as performing data recovery of those same computer-related devices.
Did you have any specific education or training to learn about forensic data?
Absolutely. I have professional training both from courses I've taken, as well as I have a master's in digital forensics from George Mason University, a master's degree in that. I've taken multiple courses, advanced mobile analysis, iOS forensics courses from SANS, computer forensics courses from SANS. I have multiple certifications. I hold the GIAC GCFE, which is...
The reality is that the jury is comprised, likely, of humans. And humans are going to come in with certain preconceptions and biases. And I don't know how much they're going to be trusting the digital forensic take of someone who looks Amish. So it's definitely a factor, which if you're putting her up there, you see that and you're not happy.
The GIAC Certified Forensics Examiner. I also hold the NWC 3CFE, which is a Certified Forensics Examiner.
Do you, through your company, teach other forensic examiners how to study forensic data?
Correct. I teach government agencies, both federal and state and local, how to do digital forensic analysis, as well as private sector digital forensics examiners.
I'm just shocked she didn't major in interpretive dance.
Forensic examiners. What's the method?
I've developed an online virtual course that we teach virtual live, so I'm always there when I'm teaching, but I also have a team of instructors. So for example, the mobile forensic analysis course that I developed right now this week is being taught to a police department in Texas right this moment.
Forensic data analysis seems like a broad field. Is there certain parts that you focus in?
I personally specialize in mobile phones and Internet of Things devices.
Oh my God.
I want you to just give us some very basic, very general. And
I need to take this seriously because I'm playing a role very, very seriously here. But if you're not checking the chat, you should, because oh my God, this is just, the chat is killing me.
Brief background. When you're looking at a forensic device and you're analyzing it, do you rely on any tools?
That is a really interesting question. Reliance on tools is not precisely what we do. We utilize tools to extract data from a device.
She has more hair.
And we utilize a variety of tools
than anyone in that
attempt to parse results from those devices. But the forensics examiner has to take the additional step to both understand, validate, and provide meaning to those results.
is there any shortcomings or dangers in simply relying on a forensic tool for a result or an opinion?
There is absolutely a danger in just relying on parsed results. When an algorithm is used to determine what data is stored as, it doesn't tell you what that data means, and that's where you need a forensics examiner. Tools don't necessarily understand how the data got there and what causes the data to exist, and that takes deeper and further human analysis, as well as, you know, if you think about it, if on your phone you can go to the Google Play Store or the App Store, and you can actually download millions of apps. There's like 6 million apps between the two stores. Digital forensics tools maybe support generously 1,000 applications. So in order to be able to parse and understand the data from applications that the tools don't know how to support, you need a forensics examiner who knows how to dig into that data, conduct testing, and determine the meaning of the data.
Were you asked by the Norfolk County District Attorney's Office to look at and analyze a phone that was related to a person by the name of Jennifer McCabe?
Yes, with a very, very specific scope to a specific date range.
Were you asked during that scope and date range to analyze it and provide an opinion about whether there were any user-initiated deletions of any web searches or Safari-type searches?
Yes, I was asked to look for deletions of Safari searches within the scope of the time frame that was dictated by the purpose of the exam.
Were you asked to look at the phone device and determine whether or not there were any user-initiated deletions of phone calls on the device?
Yes, I was asked to look for deletions of phone calls in that same date range.
And did you do both of those tasks?
Yes, that's correct.
Did you ultimately have opinions on both of those issues?
I do have opinions on both of those issues. That's correct.
And in engaging in the efforts to answer those two questions, did you necessarily have to review and analyze a web history that included searches on January 29th, 2022 at 2:27 a.m.?
I did analyze web searches that occurred at 2:29 a.m. In local time here in Norfolk on January 29th, 2022 from the device that was provided. Yes, not the device, forensic image for clarity.
So before we get to the two opinions that you were asked to consider or what your opinions were after analyzing the data, I want to begin by giving the background and having you share with us your analysis and your observations and opinions about the search on Safari relative to this 2:27 timeframe. Before we begin that, let me just ask you one question. Did you do anything to ensure the integrity of the data that you were looking at?
Upon receiving the forensic image, the first thing I did was I did what's called a hash of the image. So a hash is an algorithmic representation of a file. So a forensic image, all the data from the phone, it comes in one file that can then be extracted and have the rest of the data.
Just focusing on Jen McCabe.
That singular file that's received, there's actually 3, but focusing on the one that has all of the data, that archive file, you can run what's called a hash algorithm against it. There's actually multiple hash algorithms, and I hashed it, and then I validated that hash to the document that was provided along with the image file that contained the hashes that were contained in. Those hash values matched. Now, just for clarity, if you change one bit in a file, it will not have the same hash. So the hash provides integrity, and having used both hashes, which are available in that report, and ran 2 different algorithms, they both matched. Additionally, I reviewed the PDF that was received for signs of alteration. The PDF that comes with a Great Key report is not signed by Adobe Acrobat. However, I was able to take that PDF and then examine it just like I would a phone. So I'm using the same techniques on the phone. Using a tool called EXIF tool, I was able to learn a lot about the creation of that particular PDF. And what I was able to learn about it was that it was created by, it's labeled it as being produced by Grayshift using a particular code-based application to create the PDF called PYF PDF, standing for Python Framework PDF. It is on, it's a program that you can download, and developers who create tools like Magnet Forensics, who owns the Gray Key, utilize that script, which is why it says it's produced by it, to create the actual PDF. That's what the evidence there in the data tells me. It also contains a time of when that is created, and that time was February 2nd, 2022 at global UTC, that's the global constant time, think what's in the UK, at 22:49, which local time would be 5:49 p.m. So that says that it was created approximately 2 hours and 45 minutes after the document said the image started, and it correlated with the document information. So that provided some level of certainty that that document was factual. And on top of that, I further opened the file of that PDF in what's called a hex editor, which lets me see like every byte, every 1 and 0. And from doing that, I looked for tag markers that are made sometimes in some modifications of PDFs called XMPs, which is Adobe's format of markup. And I did not find any evidence of those tags.
When you're trying to determine whether there's integrity in the data, are you able to tell whether or not there's been any alterations or tampering before the item is put on the Gray Key machine to make the extraction?
That would be when you're talking about if the physical device had been manipulated, is that correct?
Yes.
I cannot tell if the physical device has been manipulated prior to it being imaged. I can only validate if the image was correct. In theory, all of the data of anything that you did on that device would still show in the evidence of device logs and whatever locations that were touched or communicated with. But at that point, it's the same as any user interacting with the device itself.
After the phone's extracted or at the time it's extracted, does it have the history of the device on that extraction?
Could you rephrase?
Yes. At the time the phone is extracted and the copy is made in the PDF and the digital copy, does the digital copy and the PDF contain the history of searches and calls and other items on that phone?
The forensic image itself contains a variety of different artifacts or traces that are left behind by activities that a user does on a phone. Yes.
You use the term artifact. What does that mean in a basic sense?
I'm just going to pause for a moment and point out that, look, you can't ignore, as I said, you can't ignore how she presents. And if the defense was able to come up here and say another court basically rejected her as not being science and implies that she's a crackpot. I mean, everything she says would just likely be dismissed by most of the jury. So I can understand that. She's able to be questioned about her methodology. Somebody were asking about like the ruling of the judge. She can be questioned about her methodology. They just can't invoke anything that happened in another trial related to her. That's where the cross is limited. They can't say, hey, another court just said that this similar methodology is crap. But they can question her about the methodology that she's testifying to here, and they certainly will.
An artifact is any type of evidence that is left behind on your phone of an action. So, for example, if you receive a call, there are multiple places in the phone that show that a call was received. That can be in the call log. That could be in a notification. That could be in a unified log that tracks the activity that the phone's doing. There's multiple locations, and each one of those residue of the fact that the call came in, that's what I would refer to as an artifact. So you could have an artifact not just about a call, about a web search, about taking a photo. Any action you take on your phone may create an artifact.
I'm laughing because this is a legitimate
Before
question
we get into the two questions
funny.
about any alleged deletions from Safari, a Google search or an internet search, and any alleged deletions of phone calls, I want to start with you, your explanation or your sharing how the timestamp works relative to that search beginning at 2:27 a.m. on January 29th, 2022.
So for clarity, there's more than one search that happens actually at 2:27. There is some activity that's looking at, and I don't want to mispronounce the name of the town. I'll try Hockomock Sports, looking at activities for the sporting events at that school system, I assume, or county location.
Oh my God.
There is a timestamp for the search "Hawes Long to Die in Cold."
Mm-hmm.
However, that timestamp isn't about active searches. It's about the time that a tab was either opened or moved to the background. So "Hawes Long to Die in Cold" is the most current search in the tab that you opened at that was opened at 2:27. So if you're using your phone and you go to your browser, you have some choices. You can just open an existing tab, or you can open a new tab. A new tab was opened at 2:27 a.m. and that search was done there. Another tab, actually at 2:27, was moved to the background, and its last search at the time it was moved to the background was for, I believe it's Raining Men, the YouTube video. So those two searches both exist as what's called browser state searches, but that browser state isn't about the time that it was searched. It's about the time that the browser tab that you opened either went to the background, or if it's never been moved to the background, the current search. So the time in the instance of the "It's Raining Men" video is the time that that video was moved to the background and the new tab took over as the tab that's active. And that tab, the last search done in that tab is "Hawes Long to Die in the Cold," because that database holds the current search. It constantly gets updated, and the time that the tab was either opened if it's the first time it's opened, or moved to the background if it's an existing tab.
Did you put together an exhibit that would help explain some of the different databases?
I did put it together an exhibit that would show that.
May I approach?
Yes.
Handing you a piece of paper, do you recognize that?
I do. This is table 1 from the first report I created on this case on the phone that I was told was for Jen McCain.
Is that the exhibit that will help you explain?
It will.
I move this to evidence.
Who you approach, Charlie? Or not that good, Jack, if you want.
Wow. Oh my God. If you're not on my chat, you have to be. You have to be. Oh my God. If you're just watching afterwards, I feel bad for people who are in Rumble missing the YouTube chat, and I feel bad for the people in YouTube missing the Rumble chat. I'm the only one who gets to watch them both just converge here. Although I should make sure I didn't miss any more rants, because rants don't come up in my purview. So I probably didn't miss a rant or two here. If PDF hash doesn't match, I must have quit. Here we go. I think I got them all now. Trying to catch up. I think we're live now. Yeah. I don't understand. It's hard to pay attention to what she's saying because of the chat. I'm not going to kid you, but what I did gather from what she said is it's a little confusing. You open up a tab and then you switch to another tab. It records the time that you switched out of that tab. So you open a tab at 2:25 and then keep it open for 2 minutes, and then switch into something else at 2:27. Then it'll show the 2:27 time. But wouldn't that just then change again when you change that tab? Like, The other guy, and here's a thing which it just trying to focus here from the logic perspective of what's being presented to this jury, assuming they're not giggling the way my chat is, which is very possible, if not likely, if not a certainty. But assuming that there are some people in the jury that are paying close attention to what she's saying there, this seems to be conflicting with what the state's previous witness testified to. Because she's saying, one witness here is saying that it goes by when the tab is opened. The other is saying it goes by when this one now is coming along and saying it goes by when it logs in the time that a new search is done. Those are two different things. So, you know, the state, you would think, would be trying to present one common explanation for Jen McCabe's phone here, but this is a completely separate and different explanation from what the previous experts testified to here. And they're both the state's experts. I don't think that's a good thing in presenting a clear explanation for the jury that they can bank on. Which of your experts do you want us to believe?
Before we look at any chalk, I want you to explain the entire basis for that chalk and your ultimate opinions that are reflected in the chalk. So let's start from the beginning.
May I look at my copy of the chart or no?
Why don't I just ask you?
See if you can answer the questions and if you can first.
Yes, Your Honor.
When you looked at the phone to analyze it, were you trying to determine when a particular search was made, specifically the search how long to die in cold?
Correct. I was looking for two searches, both how long to die in CIKD and how long to die in cold.
So as a forensic examiner, how do you begin the process to try to identify and determine when that search is actually made?
So the first thing we would want to identify is what application was being used at the time to make the search. So looking at that date time stamped, it was able to, on that date, be able to determine that Safari was the application that was being used as the Google browser. And then you would begin looking at the artifacts for Safari, both those that are parsed by the forensics tools, but then further looking into the data structures that hold that data itself, and then ultimately conducting testing to determine why a certain artifact exists.
So you mentioned the beginning step is the forensic tool or tools. Did you use forensic tools to get information or parse any data regarding this potential search at 227?
Yes, I use multiple forensics tools.
Can you share with us the multiple forensic tools that you used?
Absolutely. I used Celebrate Physical Analyzer. I used Magnet Axiom. I used just the tools I used at first. I used iLeap. There are further tools I used later, but those were the three that I started with.
What tools did you use later?
Later, I used specifically, I've used Sanderson's Forensics Toolkit, the forensics browser in Sanderson's Forensics Toolkit, which helps exploit SQLite databases. And then I further reviewed in a tool called Rabbit Hole.
To begin with, Celebrate, is that a tool that you're familiar with?
Yes.
Is it a commonly used tool in the industry?
Yes, commonly used mobile forensics tool.
Is it reputable?
Highly reputable.
Why did you use Celebrate?
I use Celebrate because on any mobile exam, I'm going to validate what is captured by Celebrate and Magnet Axiom because they have the most robust parsing of what is in my tool arsenal. And then I would also follow up with iLeap closely behind because iLeap has a lot of artifacts that aren't supported by either of those tools. Using a variety of tools is going to give you different coverage, and each tool has a different perspective on how they view and display data.
You said you also used Magnet Axiom?
That is correct.
Is that a leading forensic tool as well?
Yes, that is also a leading forensics tool.
Are you familiar with that company?
I'm very familiar with Magnet Forensics. I was actually their director of forensics for 5 years, then continued to consult for them for an additional 2 years under my company, Hexordia, and my company continues to be a reseller of Magnet's products.
You mentioned different tools may present information a different way, do those tools change the underlying data at all?
That's a great question. So when we're talking about the results that a tool shows, the tools maintain the integrity of that original forensic image. And that's actually something we verify as we continue through our exams to make sure that the underlying data hasn't been changed. There are some tools, I did use some other tools, I apologize. I also used ArtX and Mushy. But ArtX is capital A, lowercase RT, capital E, lowercase x, and then Mushy is MUSHY. You're welcome. I'm sorry, can you repeat the question? I got this, the spelling threw me off.
I mentioned, or I asked you about using multiple tools and whether or not the use of different tools changes the actual underlying data.
So the actual underlying data is always maintained, and we do validate that. Some tools allow you to see parsed results and then allow you to dig deeper into looking at the actual files and data structures. Those would be tools like Cellebrite, Physical Analyzer, and Magnet Axiom. Some tools show you the parsed results and tell you where they got them, like iLeap. It shows you the parsed results and tells you the file location, and then you would open that up in an external tool. And then some of the tools I used are not tools that parse the results, but are tools that allow me to manually look at the data structures. So they directly allow me to look at the data structures. And all of the tools I use in this instance are tools that do not change the underlying data.
Is it important or critical to go beyond the tools presentations and actually analyze the data yourself?
It is absolutely critical. Actually, in the NIST Scientific Foundation's paper from the National Institute of Science and Technology that states the foundations of digital forensic science, it states that it is the examiner's duty to not only verify and validate tool results, but also to provide meaning to forensics of parsed results.
Does software update regularly?
The software updates all the time. Typically, we get an update about once a month. And to be honest, it's not enough to keep up with how many new apps are developed and how many new phones come out and how many of your applications get updates, new features, for example, maybe in Instagram or Facebook. So the tools update very, very regularly.
When you use the Cellebrite tool to analyze the 227 search, did the search "How's Long to Die in the Cold" have a timestamp on it?
There are actually multiple artifacts for "How's Long to Die in Cold." Remember earlier we defined an artifact and we spoke about it was one of the types of traces. So there are multiple traces for that "How's Long to Die in Cold." Only one of them is associated with the 227 timestamp, but there are other instances of evidence of that was parsed by Cellebrite.
Is there any danger for an untrained eye to rely simply on the software when looking at a search like this, "How Long to Die in the Cold," and seeing the 227 timestamp?
Absolutely. There's a really scary danger that an examiner who has not dug into the artifact and tested to see what it means may assume erroneously that 227 timestamp is the time that what is there is searched. The search in that field of that artifact is going to always be the most recent search in the tab, but that timestamp actually means either the time that tab was backgrounded or if it's the first time the tab's been opened, when it was opened. So you could erroneously implicate a search was done hours or some time period or even days before it actually occurred. Some of us leave our tabs open forever.
In your teaching, examiners and students, do you teach about this specific concern and concept?
Yes, I teach about this concern both in my mobile forensic analysis class, my mobile forensics course that I teach at George Mason University and their digital.
If you can get past how she looks and sounds, as far as her voice, what she's saying, she presents herself as being competent. Like if you were just, if a blind person was just listening to, there's someone you were reading a transcript of what she's saying here, everything here sounds professional.
Forensics Master's Program, and in the data structures course where we specifically learn how to analyze these databases in question.
In your experience, how common does an untrained examiner make this mistake?
I wouldn't be able to speak to how common an untrained examiner does it, but regularly my students get those questions wrong on earlier examples I give them in class to kind of indicate to them that they could easily make mistakes without understanding meaning, and I use it as a teaching aid. So teaching, 90, 100 easy students a year, I regularly see that in untrained examiners that I'm teaching in my class, but I wouldn't be able to say that across the discipline.
You mentioned that Celebrite showed the search on the report as How's Long to Die in the Cold with the timestamp of 227. Is it 227:40?
Yes, that's correct.
Do you know whether or not Celebrite has updated its software?
In May, Celebrate of last year, Celebrate made an update to their software actually to remove this artifact because of its ambiguity and the risk that an examiner may overstate or misstate what it is.
Is this ambiguity reflected in other types of software?
Could you rephrase, please?
Sure. For example, when you did a report in Axiom, did it have similar reflection in the report?
Objection, Your Honor.
Ask it differently.
Did you run a report regarding this time frame through Axiom software?
I did process the image through Axiom, yes.
When you did that, was it the same or a different result?
Axiom and Celebrate really show their data very, very differently. So Celebrate takes a perspective of alerting people to possible deletions by annotating either a question mark or a red X next to artifacts that come from different areas. Magnet instead marks if the artifact was parsed or carved. I feel like now I need to explain to you parsed or carved. So parsed means that the data was where it was expected to be found, and the algorithm was able to cleanly see that this is there. Carve means that it had to run that algorithm against the data structure as a whole and found it as a partial result. So it carved it out, went and found it instead of it just sitting there exactly where it was expected to be, and shows you both the results. So it'll show all of the results of, in this instance, the sessions, tab sessions, but the data browser DB, the tab state, it's going to, instead of telling you this has a red X, it'll instead say it was carved. So it's a different presentation of the same data.
So I want to talk about deletions in a little bit, but I want to get back to the 227 search.
Sure.
So when you produced or you looked at the report for Celebrite and it showed this timestamp as well as the phrase, how's long to die in the cold, where did you look? How did you make an analysis to determine whether or not that search was actually made at 227 or another time? What was your next steps for us?
So in looking at that timestamp, the first thing I did was actually go and look at what literature exists on the artifact, if anybody had reviewed this artifact before. I also created my own data set and tested how we could get what that timestamp means. So if I make a search in a tab and then I make another search in the tab, which timestamp is it? If I make a search in a tab and then open a different tab, what changes? I also looked at the documentation in the artifact reference guide for Axiom, which does state, it describes that timestamp as the time in which the tab is backgrounded. And it gives a stipulation that in certain circumstances, the timestamp can be earlier than the search.
Did you specifically look in any databases or for artifacts in the data to help make an analysis of when this search happened?
Of when the search happened as a whole? Absolutely. So there are multiple databases that I looked at that show search information for Safari. So I looked at the plist, mobile Safari plist. I looked at the browser state database. I looked for the history database. I also looked at the Knowledge CDB. The Knowledge CDB is a little bit different. That isn't a database for Safari. It's a database for all of Apple, so it can predict your behavior. So it takes in information that Apple wants to take in, including browser history, and it saves that information so it can make predictive information. I also looked at the caches in the Safari, which is the things that Safari is trying to make quick reference to. This would include suggested terms for commonly searched items.
When a URL or a search through Safari is typed in, or if it connects, does it leave a trace in different parts of the computer or the phone?
Yeah, so when you actually do any search, you're going to leave traces. Now, it does depend if you are in private browsing or non-private browsing. So non-private browsing is what most of us use regularly. Private browsing might be what you elect to use. Well, some people would elect to use it if they're doing searches they wouldn't want their spouse to see, like maybe they're looking at porn, or maybe you're doing something secure like looking at your banking information. You may intentionally use a private browser. For Google users, this would be the equivalent of incognito in Google Chrome, and you may intentionally use that. And so the artifacts for that are more limited than the artifacts for non-private searches. So some of these artifacts only exist for non-private searches, and some exist for private searches.
And in this case, this phone, was it on non-private or private?
So specifically the two searches we're talking about, how's long to die in cold and how long to die in CIKLD, excuse my differentiation there. Both of those searches were done in non-private browsing.
So they weren't hidden?
I don't understand the question yet.
Was there any applications on to mask those searches?
Not to the best of my knowledge. I did not see any.
We began with the 22740 timestamp. The next recording on that tab, do you recall what time that was?
I believe the next, and I'm trying to remember the chart from memory, if that's correct. So I believe the next thing we're looking at is the 623 suggestion from Apple search terms for how long to digest food. Am I matching what you're seeing on your chart?
Well, let me ask you.
Okay.
When you saw that, do you look on the same tab or a database? Where do you find that information?
Fair. Understood. So all of those databases I was just mentioning before, we're looking at all the parse results from all of those. And I was looking in the entirety of the scope from the time of midnight till noon. That was the time frame of my scope of all of the content that was done in the tabs for browser state DB, cloud tabs artifacts, History DB, Mobile Safari plist, Knowledge C, each one of those. And then I was combining them to timeline out the activity.
At 62351, did you look into how long TIDIE in CIKD?
So that would be the next thing that we see after the Apple suggested term of how long to digest food. That's the next thing we see an entry of that. There's two immediately next to each other. I don't remember the precision on the seconds of which one's first off the top of my head, but one is in Knowledge C and one is in the Mobile Safari plist.
Can they appear in different rooms in the data bank in different places, the same search?
Searches appear in many different places. They can leave traces, such as that Knowledge CDB. I love that Apple calls that knowledge. It's like what it's trying to learn. So the Knowledge CDB, what Apple's trying to learn about you, as well as in that Mobile Safari plist, as well as at the moment of that search, which I don't have the device in that moment, but just so there's an understanding, that open tab, the URL would have been updated, or URL is the website, would have been updated to that search at that moment. Had we imaged it at that moment, it would have been how long to die in CIKD.
And finally, at 6/24/47, did you identify any artifacts with that search that appears with the timestamp of 2/27/40? Did you find the same?
Correct. At 6/24, we have 2 timestamps in the same 2 locations for Hoslong to die in cold, the Knowledge C and the Mobile Safari PLS.
So based on your analysis in that issue, did you come to an opinion whether or not the phrase "how's long to die in cold" was actually searched at 2:27 a.m. on January 29, 2022?
There are no artifacts.
So the answer is yes or no?
Can you repeat the question,
Yes.
please?
And so based on your analysis of the phone and the data using all of those softwares, did you come to an opinion whether or not the phrase "how's long to die in cold" was searched at that timestamp tab of 2/27/40?
Yes, I came to an opinion.
And what is your opinion?
Rephrase the question as to the opinion.
I'm sorry?
I'll see
He's
you
like,
inside also, Mr.
what's wrong with my question? He's like, wait, why can't I get an opinion out of her? She's an expert witness. I am confused about what the objection is. I am confused about that. I don't know if this is a Daubert issue. That's not scientifically. I don't know. There's too much out of our purview for me to assess with confidence as to what the nature of this is. So yeah, I do think she sounds competent. If you're reading a transcript, I think that she would be much better if you could read a transcript of what she's saying than actually having her present it. She also talks with her hands a lot. There's a lot to the way she presents, which leaves that which to be desired, that I think a lot of people would find somewhat off-putting. I feel as if you cut off her hands, she would be mute for the rest of her life because everything is just I don't know. She's like signaling planes to come in or something. I don't know. Something's happening there. But all that being said, the information she's providing does sound as if she has a high degree of competence in this area. So likely most of the jury, the ones who are paying attention, some of it was boring as all hell and just confusing. But she definitely seems like she knows more in this area than a typical juror or than I know. So let me do a double check and make sure I didn't miss anything. I was worried that Rummel rants don't show up in here, so I always have to like do a double check into the ghetto. You're all getting a feel for how often I check the ghetto. Isn't Tanny, but is there some reason they can't just get the search time from Google? I'm pretty sure they have it. I don't know. That's an interesting question. I don't know if they subpoenaed it, if they can get something. Why not get someone from Google to come in and testify? Chad's having way too much fun in this. Almost certainly. Almost certainly. That's a fair point. That's a fair point. If Karen Reed's phone had this search at 227, we would be seeing both sides playing opposite roles. That's what you have to do as advocate. So it's a really good point. No, the jury cannot hear the sidebar. That's why they go to sidebar, Rachel. They go to sidebar specifically to be out of earshot of the jury. In the Johnny Depp trial, which I went there for one day down to Virginia for that. In the Johnny Depp trial, was that within the last 2 years? Maybe I can get a day out of that for my. Oh, that's not New York. That wouldn't help. For the Johnny Depp trial, they would have this static noise playing, this white noise that was playing. And you couldn't talk. They had these bailiffs who were marching the aisles there, and if you spoke at all, even during the sidebar with white noise there, if you spoke, bailiffs would come up there and throw you out. And you're gone. And you had to wait all night to get in there. So no one spoke. They'd write notes to each other. So, yeah. So, it was very loud. It was very loud. I don't know if they have white noise here. As soon as it came on, I was like, what the hell is that? I've never seen that before. I wanted to like throw a question out there of like, it's gonna be a Leslie, not AJ, but same point. But yeah, I want a Leslie to be like, so someone ran a search for Trump is the greatest president ever at 225. Totally trigger her. Totally trigger her. That would completely set her off. I think we'll still have her. I think she'll still. I don't think she's going to finish. Although normally when they're asking for the final opinion, that's a sign that we're near the end of this expert witness, and that there's fewer than 10 questions left. It'll be interesting to see if we get this cross completed before lunch.
You've explained to us the analysis you engaged in and the process you engaged in. In forensic data analysis, is there a methodology that you use, not just looking at the printout of the programs, a methodology you use that is accepted in the industry for experts?
That's what it was.
To analyze
it was a
data and
Daubert
come
thing.
to your opinion.
Absolutely.
That's so. What the objection was, we can glean based on the new question he's asking, that he said you didn't have proper foundation to lay scientifically how she reached her opinion rather than just being crack pottery. So she needs to lay that foundation, and in order for us to have a better opportunity to understand what the basis of her opinion is. You could ask yourself strategically, why would the defense do that? Why would they want it to help potentially bolster her testimony by helping her lay out that foundation for what methodology she used to search here? It's because it's difficult to cross unless she locks herself in that these are the steps I took and things of that nature. So you sort of you're going to need to get that out of her anyway for purposes of showing how flawed her approach was. So that's what That's what's happening. That's what happened there. They said she didn't establish foundationally how she reached her conclusions. She can't issue her conclusions yet. And the judge agreed with the defense on that. And that's why now Brennan is laying that foundation here.
Beyond looking at what was in the tool results, I further looked at those databases independently and conducted testing of the artifacts.
And in addition to what you did, can you share with us how and why this methodology is accepted in your practice as forensic analyst?
This methodology is accepted by NIST and by organizations like the Scientific Working Group of Digital Evidence. I'm intimately familiar as both a member of the Scientific Working Group on Digital Evidence, who helps work towards the building and development of these consensus-based documents of procedures to be followed in digital forensics analysis, and as a member of the National Institute of Science and Technology, NIST, Organizational Scientific Area Committees, OSAC, Digital Evidence Subcommittee, where we also produce guidelines such as the data set guidelines for generation of the guidelines for data set generation, which is how you do your actual testing and creation of data sets. And I was also a part of the subcommittee that drafted that. So I'm intimately familiar with the accepted policies and procedures because I am also a member of the groups that help author these, as well as review them and look and use them.
Are there articles and guidance in the industry about this particular practice of analysis?
For analysis, just for clarification, you're talking about for analysis of Safari artifacts, of mobile forensics, of browser state DB, just for clarity on the question.
Let's work our way through it. How about
Sure.
through Safari?
For Safari, there are multiple different blogs that talk about Safari, as well as I have analysis of Safari through classes I took, such as SANS 4508, which is their, 518, SANS 4518, which is the Mac and iOS analysis course, which I took.
How about the specific guidance regarding searching the different databases for artifacts?
In terms of methodology for digging into databases,
Yes.
Is that correct? There are multiple, I've taken courses throughout my master's program, courses on how to analyze digital forensics artifacts, including mobile device forensics, throughout my GIAC certifications. I've taken multiple instructor-led courses on how to do these, as well specifically that cover mobile Safari history in mobile forensics at GMU in his master's program as part of the SANS 4518 class. And in terms of data structures, I've taken study on how to analyze databases like SQLite and PLIS are covered in those courses.
There are books on study on this methodology?
There are multiple books on digital forensics, many of which I've read, and including books specifically on analysis of SQLite databases, such as Sanderson's SQLite Forensics, which is probably the most authoritative because not only was it written by Sanderson, who makes a tool, it was tech edited by 3 renowned forensics examiners, as well as Dr. Richard Hipp, who created SQLite itself.
The methodology, the technique you use to look past the reports and actually look at the data to make your determination and arrive at your opinions, is that methodology regularly accepted within the forensic data community?
Absolutely. Again, using the methodology from the consensus-based documents from the community, from the Scientific Working Group Digital Evidence on best practices for analysis, as well as specifically for the SQLite databases I was looking at. I do that deeply verifying and in accordance with the understandings from Sanderson's book.
Now, you share with us that you had an opinion regarding the timestamp and whether that it was applicable to the search term, "How's long to die in cold?"
That is correct.
Now, I want to ask you, to a reasonable degree of forensic data, scientific certainty, what is your opinion about whether the phrase "how's long to die in cold" was made at the time of the timestamp 2/27/40?
Your Honor, may read for
the last time, Mr. Massey, on this issue, okay?
I don't know why you're saying it's the last time. They won on the last one. So what are you saying it's the last time? Like, why would that be the last time? It's like, let's get this right. I don't understand that at all. If you're wondering, I did do a Google search for Jessica Hyde. Those of you who are wondering what she looks like, you know, which you have to look her up as Jessica Hyde Hexordia, otherwise you're not going to get the same find. You'll get a different Jessica Hyde. And this is her hair here. I don't think that's her. Pretty sure that's not her. Maybe that once was her. I don't know. But this is like her. So there you go. Apparently she understands hiding in plain sight. So there you go. That is Jessica Hyde. All right. Coverage, subscribe to this MF people. Thank you, Carlos. I appreciate that. If you all can, please like and subscribe. That is why we do this. You might be wondering, Joe, how's that whole recruitment thing going? How the numbers going? Are you going up? The answer is sort of. When I checked yesterday at one point, that was 100,326. So we moved up 16. Yeah. Yeah, baby. Yeah. Oh, God. Those losers who have 100,300 and only 40 people. Suckers. Eat that, suckers. But if it is free to subscribe. It is free. I'm kind of ready for the lunch break, not going to kid you.
All right, go right ahead, Mr. Brennan.
I'm now going to ask you for your first opinion. So you shared that you have an opinion about whether that timestamp 22740 was, whether or not that was the time the search "How Long to Die in the Cold" occurred. Can you tell us, to a reasonable degree of scientific certainty, your opinion about whether that search, "How Long to Die in the Cold," occurred at 2:27:40 a.m. on January 29th, 2022?
Same objection, Your Honor.
Okay, the objections are overruled.
You state
What
the
I can
objection
state to a
preserve
scientific
it.
degree of certainty is that that search occurred at 6:24 a.m. and was the last search in the tab that had been opened at 2:27.
Last search in the tab that had been open at 2:27. Okay. All right. That's what she's testifying to. Fine. Okay.
Do you have an opinion, to a degree of scientific certainty, whether there was any other searches similar to "How Long to Die in the Cold" that evening on that tab?
Objection, Your Honor.
I'm going to allow it.
May I first inquire, you meant morning, I
I'm
assume?
sorry, that morning, yes.
Just clarifying, I did not look at evening searches. And can you repeat? I apologize. I disrupted my own train
You
of
have an
thought.
opinion to a reasonable degree of scientific certainty whether there were any other searches on that tab before the final search at 6/24/47, How's Long to Die in Cold.
Overruled.
Just ensuring that I have the question correct.
Please.
You're asking
It's
if
the CIKD.
what else occurred in that tab prior?
Yes.
That I cannot say with a clear degree of certainty.
Did you develop a chalk that I
I
showed you
did.
earlier?
Yes.
Like to approach?
Yes.
Interesting.
Again, I show you.
That's a great point. Okay, a couple of things I want to point out to you. Number one is that the defense has to object and get overruled if they want to preserve their right to appeal. That's why they're doing that. So you object, overruled. This way, at least you can appeal it and bring it up later on, and this is potentially reversible error, which can overturn the entire trial, assuming that the judge is wrong on the law here. So that's what's happening there. Interesting that the previous searches, that actually makes sense. How do you know that the How's Long to Die in CIKD, where she misspelled it, if you can only tell me what the last thing is and what time it was open, how do you know that the How's Long to Die in CIKD didn't happen at 2:30 in the morning? It could have. It could have. You don't know. So that's a reasonable. That's actually showing some, scientific integrity here. That she's like, I can't tell you what time that was.
What is it?
It is the exhibit that I created that was labeled Table 1 in the first report I had delivered.
And does that provide information that will assist us in understanding your opinion?
Yes.
I'd move subject to redaction that this be introduced into evidence.
Your Honor, I have no issue with regard to the redacting aspect, but consistent with my prior objections, I would object to that.
Okay, I'm going to allow this into evidence. Your right to say it.
Thank you, Your Honor.
This opens up a huge doorway. I'm going to make myself a little bigger here to make sure that anyone is looking for this. This opens up a huge doorway for the defense. The fact that she cannot say what happened between 2:27 and the last search at 6:24. Because one of the things the defense has been saying is that Jen McCabe did that search at 6:24 to try and hide what she had searched for earlier. And this expert here cannot refute that. That Jen McCabe, basically, the reason she was searching later was to try and hide the fact that she had been searching for the same thing or similar stuff at 2:27 in the morning, or 2:30 in the morning, 2:45, hours before O'Keefe's body was found. And this expert here has just admitted that she cannot rule that out. So for all we know, this own witness could end up being consistent with the defense's theory that she did this search at 2:40 in the morning, trying to figure out how long we need to leave this body out here for it to look dead and for it to make sense. And then at 6:20 in the morning, decide to try hiding that by doing this whole thing of like, oh, now that we found him, let me look for this again. And this way, trying to erase that search. That's that's potentially highly significant to the defense.
Madam Clerk, 82.
Exhibit 82.
Thank you. With the court's permission, I'd like to show Exhibit 82 to the jury.
Okay.
Could we enlarge the first two? And we're going to need to get the right column in if we can, please. Thank you. Ms. High, can you see it from there?
I can. Thank you.
If you can walk us through how this exhibit assists us in understanding your explanation and the basis for your opinion.
This exhibit shows the Safari artifacts and artifacts of Google searches in Safari related to the two searches in question, How Long to Die in CILKD and How's Long to Die in Cold, that occurred on the morning of November 29th, 2022 on the device under examination.
if I look at this chart and I see in the top left, it says 2:27:40 a.m. And then under the search term, it says, how's long to die in cold? How do I understand your opinion that that search didn't happen at 2:27:40?
This document is showing you the data that is the parsed result. The source of that artifact that you see in the last column is a little bit cut off, the browser state db-wall file. That database does store how the data is stored, the search term, how's long to die in cold, with an associated MAC absolute epoch timestamp that translates to 2:27 a.m. That is what is physically stored. That does not annotate the meaning of that artifact. That was determined through testing following the NIST OSAC data generation guidelines for testing.
In the second row, we see a timestamp on the left-hand column, 6:23:49. And it provides artifact, the cache record.
Mm-hmm.
What is the term? And what does that mean under the search term?
iOS Safari cache records. A cache refers to something that a computer program wants quick and easy access to. When we search on our phones, anything, a lot of times, be it in Google or in Safari, depending on what type of phone you own, it'll suggest what it thinks you're going to type in, right? So you can click it. It's trying to be helpful. In this instance, at 6:23:49, we have a cache record that indicates that Apple suggested the phrase, how long does it take to digest food?
And then under that, 6:23:51, it appears it says a recent web search, and the spelling is changed. How long, TIDIEINCIKD.
So this, in reference to these two search terms, this is the first actual search that occurs at 6:23:51 a.m. Upon beginning the typing of that phrase, Apple provided the suggested search, and the person inputting into the phone at that time continued to type out a phrase and finished it as how long, TIDINCIKD, which that is available to us in the mobile Safari plist, which tracks recent web searches. And then we'll see 6 seconds later, we get that reference in that Knowledge C database that I mentioned before. That's the next line. So that's the Knowledge C database is Apple's way of keeping knowledge about what the user's doing. It sees and holds your knowledge. It's an easy way to remember it. That's what I teach my students. So that Knowledge CDB tracks a lot of things for predictive purposes. And so 6 seconds later, it's logging that same search. So that search is being tracked in 2 places.
And so one search can be left as artifacts in different locations on the database?
Correct. There can be multiple traces or artifacts of the same user action in different places on a mobile device.
And if we go down to the bottom, the last column, at 6:24:47, we again see how's long to die in cold. And if you look in the first column, it's the same phrase. Is that a coincidence that it appears at the bottom at 6:24:47 and also appears up at 2:27:40?
As mentioned before, through testing of the artifact for browser state DB, that artifact will hold the most recent search that happened in the tab. So it is logical that how's long, HOS long to die in cold, was searched at 6:24:18, tracked in that mobile Safari plist, repeated in Knowledge C, Knowledge made its tracking in Knowledge CDB, and then that table for browser state DB, which again has the time that the tab was opened or the last time it was backgrounded, and updated just the website that was visited. So the website, that is why we get that 2:27 time. That's actually, as far as the data storage is, the first thing I have in there, because I want to put it in chronological time order for exhibit purposes, is actually the last thing to happen because it's the update to what's in the tab.
You offered that the how's long to die in cold is the last thing to happen. Do you have an opinion to a reasonable degree of scientific certainty the time when that search was made?
Objection, Your Honor.
To a reasonable degree of certainty, I can say that How's Long to Die in Cold was searched at approximately 6:24 a.m.
Now, moving on from the 227 search, there are two other issues that you were asked to analyze. We talked about them at the beginning. Let's begin with whether or not you looked at the data and analyzed the data and came to any opinions about whether that phrase, "How's long to die in cold," was user deleted on that device.
So there's two really key elements as to if that was user deleted. If the question is, did I come to opinion? Yes.
And can you explain how you came to an opinion that we'll ultimately share with the jury?
The first line in that exhibit, the ending of that, if you remember, it said browser state.db-wall. That's important. So we'll talk about that in a second. But the first thing I want to bring up is kind of how the database works, because I didn't just look at the tool result. I extracted that database and I did a deeper analysis on it using Sanderson's tool, because that information was in that -wall file. So when a SQLite database, which is a specific way of storing, very, very common on mobile phones, actually one of the most common, when that database stores data, it has two versions. The most recent version, and the version in use here, uses what's called a write-ahead log. So before data is committed, it is written to a write-ahead log. I'll kind of explain it. So let's say we're in a restaurant and we're sitting at a table and we're ordering food. Our table is the table. Data is going to come to the table, and that's going to be our food. So when we order food, let's say we've got a chicken sandwich, a burger, and a pizza coming to the table. The chicken sandwich, the burger, and the pizza, the kitchen puts it in the warming area. It's the write-ahead log.
Brunch.
The server grabs it from there. It's where data sits before it goes to the table, just like your food goes to that serving station before your server brings it to your table. Server brings it to the table. That table's got its burger, its chicken, and its pizza. Another table orders waffles and pancakes. They think it's breakfast. The waffles and pancakes are made by the kitchen. They're put on the serving area. Waitress comes over. This pizza has pepperoni. I don't eat pepperoni. Can you send it back? Waitress picks up that pepperoni and sends it back. That's a deletion. Pepperoni pizza was just removed from the table, right? We're deleting it. We're moving. We said it's not what we wanted. The waitress is removing it. She brings it back to that serving area. At that moment, that serving area has the deleted pizza, but also the waffles and pancakes that are waiting to go out to the table. That's how a write-ahead log works. Any changes that are happening sit in the write-ahead log until the database is closed, and then when it's reopened, all those changes are made, both additions and deletions. So often when a phone is imaged, when we make a forensic image, the applications are still open, so we have those WAL files. When we look in our Safari browser, the database knows to read it to you in its current state. So it tells you where the waffles and pancakes are going. They're going to that table. So it shows it as if it's in the table, but it's not in the table yet. So if when we parse the data and we look at the restaurant and we don't look at the back kitchen, we would only at that time see the chicken and the burger, right? Pizza got sent back, waffles and pancakes haven't come out yet. So when we get the data, we get two files. We get the restaurant, that's the database, and we get the serving area, that's the WAL file. Just because it's in the WAL file does not mean it's deleted. It means that that record wasn't where it naturally sits yet. It could be that WAL file can contain deleteds and food or data that hasn't yet been delivered to the database. So the WAL file consists of both. So an assumption that the data was deleted just because it's in the WAL file is actually not true. And the peer review paper I mentioned earlier that I had accepted in Forensic Science International actually has a section that explains this exact presence for SQLite databases about how we refer to that as recovered and not deleted. Actually, through that entire document, we don't use the phrase deleted. We refer to things in statement of recovery because we need to determine why it's there. So we can't say that it's deleted just because it came from the WAL file. Some tools will automatically indicate to the examiner that.
But it could have been deleted by her. You're saying you can't, it's not proven that it's deleted, but it very much could have been deleted by her. You're just making this, you're not ruling out that she could have done it. You're just saying it's not this positive that she must have done it. That's at best. If we believe you, then at best, we cannot be certain she did, but she may have. Not that it's impossible that she did.
They need to dig deeper into that. I did do further analysis by looking at the WAL file. That particular item is a little bit more complex, actually exists on multiple pages because it moves as the database is being created, but all of them have the same unique identifier. So it's the same entry. It's not more than one search of Ha's long to die in cold. If there was more than one search that had occurred where it became the top element in that database, we would see that. There are, as I mentioned, other carved from the database, from the WAL file elements such as the search for the YouTube video, It's Raining Men, because at some point that was the last viewed item in a tab when that tab was retired right before, also at 2:27 a.m., but a couple of seconds before the Ha's long to die in cold search. So we can see that that table is put to the rear. The newest tab that's open, which is why it's in the WAL file, it's the most recent thing because it's like our waffles and pancakes hasn't been delivered to the table yet. So it can sit in the WAL file for that reason. That doesn't indicate it's deleted. The second reason is there is no user interaction in the interface to delete a tab. You can open and close a tab, and open and close tabs are tracked in that database.
All right.
But you cannot delete a tab. There's no, if you were to pick up your iPhone, I know you don't have them right now, but if you were to pick up your iPhone and look, that wouldn't be a physical option you have in the interface. So it could not be deleted by a user through the interface for that most basic reason.
So
that's
a user, could they delete a tab if they wanted to?
There's no actual option to delete a tab. For your web history, you could clear the cache, for example. Most of us are familiar with clearing the cache in your web history. You might do it because you don't want your kids to see what you searched, or maybe your kids don't want you to see what they searched, so they'll delete it. But you can't delete the tab history. It's just what tabs are there. The device is tracking that.
When you looked at the software, whether it was Axiom or Celebrite, when you look just at the report, not the data itself, do either of those reports have any indication noting that that web or that Safari search is characterized as deleted?
Tools Celebrite denotes it with a red X, which means that it is recovered. Axiom indicates that it is carved. In the same paper that I referenced earlier that I authored, there's a chart in there that shows the distinction between how different tools, some will use red X's, some will use question marks, some will list carved or parse. So every tool chooses to do that differently. That does not mean deleted. It means it needs further analysis.
Should an examiner who looks just at the reports of the software assume that if it is marked as recovered in Celebrite or carved in Axiom, should
an examiner should never assume something's deleted without doing a manual examination.
The manual examination, is that a method that's used, that's generally accepted in the forensic data field?
the NIST Science Foundation paper, as well as the data set generation guidelines, both speak to conducting testing to verify and validate, and it states clearly that an examiner is to verify and validate findings and to determine meaning.
So given that you've used multiple tools to look at reports regarding this phrase, how long to die in cold, and have seen indications or characterizations of recovered and carved, and in addition to the fact that you actually analyzed the data, did you arrive at an opinion to a reasonable
I almost threw out that that when she's ordering that lunch, that's her way of clearing cash.
degree of scientific certainty whether or not the user deleted, any user deleted the phrase, how long to die in cold?
Yes, if it's has long to die in cold. Sorry, trying to clarify.
Pardon me. Did you come to an opinion to a reasonable degree of scientific certainty whether any user deleted the phrase, how long to die in cold?
Yes.
And what is your opinion?
My opinion is there was no deletion that occurred by the user because it is not something a user can delete.
Finally, I want to ask you about your analysis of the phone records on this phone attributed to Ms. McCabe. Did you go through an analysis of the phone logs and the phone records on the phone?
I analyzed the call logs and the phone logs on the device that I was given, that I was told belonged to Ms. McCabe, yes.
Would a suggestion or a claim that a user deleted irregularly a number of phone calls, would that be accurate or inaccurate in your experience?
It is inaccurate in this instance.
Can you explain to us why and how you came to that conclusion?
Yeah, this is actually really interesting because of what it appears in the forensics tools and additional artifacts that I looked at that are not parsed by the forensics tools. So the call logs, when you look at it, it appears, I don't remember if it's 8:57 or 8:59 a.m. in my mind at the moment, but approximately either 8:57 or 8:59 is the earliest phone call we see on the 29th of January. We see no call logs before, but we do see FaceTime logs before. So if an examiner, again, was making assumptions without testing or reviewing, the first assumption might be, well, things must have been deleted because there's data that exists before, but not current data. So then you have to go, how do phone logs work? And again, create test data and review. What the situation here is that there are three types of call logs on this particular phone. There's regular calls, incoming and outgoing. There are FaceTime video chats,
well, that's on me.
This should have said
direct. I
audio
apologize.
chats, incoming and outgoing.
I had
The
that up there the whole
storage
time.
for
Don't
that
correct me.
is actually 200 records. So you can only store up to 200 of each. Now, if you were a user of, let's say, WhatsApp or Signal or Telegram, those would each count too, and they'd get their own logs. So when we look at the database for the number of calls between 8:59 a.m. or 8:57, again, I apologize, I'm not looking at that precise time, on the 29th of January in 2022, there are exactly 200 calls still in that record from then until the imaging of the phone. There are 199 FaceTime video calls and only 27 FaceTime audio calls. So the question is, how do you validate that that's what's happening? So we actually have call logs that we can pick up in other places for recent call logs in the last 7 to 30 days, depending on the exact version of the device and how the biomes are running. We can actually see incoming call logs, the number they go to, and if they're incoming or outgoing in the biomes. So we actually can see the history going back for the entirety of that day on January 29th till midnight. Again, my scope was from midnight until noon. So we can actually see all of the calls. They're just not all in the call history state DB. Now, the call history state DB, from a user perspective, that button on your phone doesn't say call history. It actually says recents. And what it's determining as recents is the most recent 200 of each category. Now, how did I determine this further? There is a running log that exists in a phone. It lasts about 3 days. It's called the unified log. The unified log tracks multiple things that are happening on the phone. In manual analysis of the unified log from this phone, I can clearly see each time a 201st call comes in, the 200th call gets deleted. So it's constantly just the last 200 calls. It may not be typical that we see 200 calls in 3 days, but on this device, we do see 200 regular phone calls in the 3 days between 8:59 a.m. on the 29th and when the phone was imaged.
Do you have an opinion to a reasonable degree of scientific certainty whether there was any user deletions from the phone call log that morning?
Yes.
And what is that opinion?
The opinion is that I can see that it's done by the device itself utilizing the unified logs, that the system is deleting the 201st call every time a new call is received or outgoing.
Thank you. I have no further questions.
All right, can I see Councilor Sidebar regarding scheduling and a few things?
All right. So I don't know if we're going to do cross before we go to lunch. They better tell us about they better tell us, like, if they let the jury go. Yesterday they took a break and they didn't tell us they were taking a break, and all of a sudden we were sitting there for like 15 minutes while they were supposed to be at Sidebar, and it turns out that they come back and they're like, well, welcome back from the break, jury. And we're like, seriously? You didn't even tell us about that? I assume if there's a lunch break, we're going to hear her say it's lunchtime, and then we'll be sitting here for 20 minutes, and then all of a sudden I'll be like, I don't think they're coming back. I don't think they're coming back. So, yeah. I'm with respect to whether or not she deleted. So this is an interesting. What this expert is claiming is that it's impossible to delete, and she's trying to come up with some theory, basically, as to why it would say delete. And it seems as if she's starting with the premise like, well, we know she couldn't have deleted it because no one can delete a tab. If no one can delete a tab, why does it say delete? And she's come up with her theory as to how that word gets generated. And that if you run a new search, it'll show with the whole food analogy that she came up with there, that would read as deleted. I'll tell you that she presents with confidence that she's definitely right, which is one of the things that as an attorney, you're looking for your expert to come out there and sound very knowledgeable and confident. So she definitely presents as if she knows what she's talking about and that she is confident once you get past the visage of and the voice and the speaking style. But yeah, so, and perhaps you have to also bear in mind that she could be singing from a jury of other people who look exactly like her. You don't know, especially in the Boston region. That's not out of the realm of possibility. But she seems like she knows. She does express herself with this background that seems like she's trying to use her training experience to come up with a logical explanation. You can disagree with what she's saying and say all that other stuff. I'll tell you this much. My personal perspective is if you ask me, like, before she even stood up here, I was like, I don't buy that she was doing that. I don't know that. I know the 227 thing looks hokey. I actually don't think that that's defense's strongest avenue. I don't think Jen McCabe was Googling at 2:30 in the morning trying to figure out how long it would take John O'Keefe to die. And it's like, we're going to throw him out there and let him die out there. Or Googling, like, how You know, how long does he have to be hiding out there for him to look dead? Everything there, to me, if you ask me, all the typos seem like someone who's frantic because they're just, you know, I don't buy that she would be searching that. I don't think she would be the one searching it. If anyone, it would probably be someone else. She's actually a friend under the theory that he died by accident in the house, that Jen McCabe was hiding it. I don't think she'd be the one looking that up. I just feel like Brian Albert or someone else in the house, not like the one who's like inviting him over, excited for him to show up. Yay, John's here. I don't believe that she's leading the charge for what steps we need to take in order to help cover up the fact that we just killed this guy, or that he died here by accident. So I do think that the whole house long to die in the cold, personally, I think it's a glitch. I think that these experts are probably accurate that it is a glitch. I don't think she searched that up before 6 o'clock in the morning. That doesn't mean that Karen Reed told her to do it, but that's my own personal perspective. I'm wondering if you agree or disagree. Do you think that I'm wrong on that she did do that? I'm saying I don't think she's that. I don't think at 2:30 in the morning when assuming he just died, and that she's trying to figure out how to cover it up. I don't think she's. I think his death would have bothered her, and she wouldn't be sitting there thinking like, "How are we going to cover this up?" She might be aware of it, aware of the cover up, aware of the death, aware of the cover up, but not that she's leading the charge on how to effectuate the cover up. That's my point. I don't know. As far as why search at 227, it could be what these experts are trying to claim, that there's something that I don't understand about how operating systems work. Again, I think we are light years away from establishing that Karen Reed is responsible for John O'Keefe's death. But that's different from saying that at 227, we have indications that Jen McCabe was trying to hide the fact that he had died. And she may have known what was happening. I'm simply saying what you're basically asking me to accept is, let's assume everything the defense is saying is correct. Take the phone out for a second. Everything the defense's theory about what happened here is correct. John goes into the house, gets into some sort of fight, punched in the face, attacked by a dog, falls backward, bangs his head. Now the family is like, oh my God, what are we going to do? This is a tragedy, and no one wanted him to die. No one was coming in there saying, tonight's the night we killed John O'Keefe. But that was an accidental death. Now this dude is laying there stiff. What do we do with him? Someone says, hey, let's leave him out in the cold. Leave him out in the cold. Well, how long does he have to be there before like people will think that he died out there in the cold rather than dying of this blow in the back of the head? Oh, I don't know. I'm picturing, in this moment in time, Jen McCabe is probably weeping because she seems to be really interested in John O'Keefe. I'm just picturing like what I would think is her emotional state. We have enough evidence that she seems very interested in John O'Keefe as a friend and potentially friend with benefits. I don't think that moments after he died, or even the first hour after he died, when they're like, okay, we got to put the body outside. Someone says, how long will it take for him to be left out there? So, and they would say, how long die in the cold? They're not having her check it up. It would be someone else there who is more detached from the situation, who would be having the calm head to say like, okay, let's make sure that we're doing this right. How long to die in the cold? It wouldn't be Jen McCabe. That's just my own personal perspective as far as understanding human dynamics and how people react and process time and stuff like that. I cannot believe that she would go from checking 5 times at 12:30 in the morning of, are you coming? Are you here? Are you coming? Look, going back and forth from the kitchen to the door. Where is he? Why isn't he in here yet? I need to give him a welcome hug and kiss hello. To less than 2 hours later, that she's leading the charge, and how do we cover up the fact that he's dead? I don't believe it. I personally don't believe it. That makes sense to me. So if the search happened at home, then why is she doing this search? And that is what, by the way, people say that none of this makes sense to me. I don't think it was her. I don't think she. If someone was looking that up, I don't even think that I doubt that they're even intelligent enough to start thinking along those lines. I think that's why I think that these explanations, as cockeyed as they sound, probably are true. I'd be falling into their trap if I'd be like, okay, now I think that she did that Karen Reed is guilty. I'm a long way from thinking that Karen Reed did it. That Karen Reed was responsible, or that we at least have proof beyond a reasonable doubt. I'm a long way from there. But saying I'm cautious before jumping into the defense's theory is not the same thing as saying I'm accepting the prosecution's theory. I'm as sufficient humility to say, I don't know that anyone here has the right theory. And the burden of proof is on the prosecution. I don't think I'm ever going to feel confident that I know what happened. Because no matter whose story I hear, I have questions. But I have fewer questions if you discount that phone search. I don't think that's what I'm saying. I don't think the phone search helps them. Not that much. Maybe. So now she wants him dead. You tell me she wants to bang him, and then she's like totally detached from the fact that he just died. And it's Googling how long die in the cold. But I don't know, I struggle with it. Sorry, this one is the one I meant to pull up. I said maybe. I don't know what the hell's happening with this jury, and I'm starting to worry that they're at lunch. I'm really worried that they're at lunch and that they never told us. I'm getting worried. All right, I'm going to assume they're at lunch. Can I assume that? Can I assume they're at lunch? I'm going to assume they're at lunch. This is exactly what I expected the problem to be. As soon as she said, let's go to Sidebar now. Who the hell's going to Sidebar? They have to be at lunch. Yeah. Oh, wait. Seriously? All right. They went to lunch. That's something. I'm assuming that. Which means I'm going to go to lunch now. So. Yeah. I'm going to come back here at 2 o'clock. Okay? That's what we're going to do. We're setting this up for 2 o'clock. I'm going to, well, in case you came late, what you missed was basically we had some kid trooper who worked alongside Michael Proctor who was talking about how he collected evidence and doing a whole presentation of the evidence. Here's his shoe, here's broken taillight, and then question about the fact that, so basically everything you worked for, you were an underling for Michael Proctor, and the guy sheepishly admitted yes. And then we had this woman come in here, this Amish woman coming in here, and apparently knowing a lot more about cell phones than any other Amish person I've ever seen. And giving her her testifying as an expert in the eyes of the Florida police that she ran that search for a house long to die in the cold at 6:24 in the morning and not at 2:27, and that she's not the one to do the search. That's the synopsis right there, what we got this morning. I will see you all at 2 o'clock. If you're wondering, hey, Joe, what is the next stream going to look like at the after lunch stream? What's that going to show? What's that going to look like? I can show it to you. I can show it to you. This way you'll be able to easily identify it when it comes up. And it's going to look like this. A little silver action going on here. It'll look like that. Day 11 afternoon. There you go. That should be up in the next 5 minutes or so. And yeah, I will see you all at 2. Till then, take care of yourselves.